his name being there, and I accept that. Therefore, I've reconsidered what I've said earlier, and in view of what I have said, it is going to be simply an untenable situation to allow the 5th and 12th respondents to participate at this stage. It can only be prejudicial to all the other parties concerned, as well as the tribunal itself. And therefore, in any event, whatever law points they were going to take, according to Ms. Muller's submissions, are going to be in line with what everybody else has responded, and they are quite happy to go along with all the submissions that the other respondents have made, based on which obviously the tribunal will give a ruling. So therefore, I've reconsidered my earlier proposal, or earlier order to allow them to address the tribunal at the end if there is time, and I am now ordering that they be precluded from participating in these proceedings. There's no rational basis to allow them for doing so at this stage, even without having read the papers. I'm of the view condemnation cannot simply be granted in this matter at this late stage. So therefore, the 5th and 12th respondents' request to participate in these proceedings is refused.
As it please the court, my lady.
Thank you.
As it please the court, my lady. Thank you.
As it please the court, my lady.
Right, Mr. Tsatsawana, I believe you are going to kick off today's proceedings.
That is indeed correct, my lady.
Right. I'm just going to reiterate what I said yesterday. Oh, and by the way, I have not seen your heads. I was surprised to hear from Mr. Arendse this morning that you had filed heads.
Indeed, my lady.
Yes,
we
not
filed heads of argument. I have a suspicion as to what might have caused my lady not to see the heads. They were filed, and then I think at some point they were rearranged and placed under a one section of case lines with all the heads of argument, and they are not like standing alone. I think that is probably why my lady did not see the heads. I don't know if my lady requires time to have regard to.
No, well, your papers have been filed, and my proposal is that, well, look, I've read the rest of the papers relating to the 7th respondent. Yes. And I'm imagining that you would have included a lot of what is in the papers in your heads together with the law.
Correct.
And so I'm proposing again to you as well as to all the others who will be addressing the tribunal. I've read the papers. If you don't mind, please, it's not necessary to repeat the heads. It's not necessary to read big chunks out of the papers or the heads. Just refer me to those paragraphs or those areas of the particular papers that you want me to give attention to. And that way, in the interest of time, we'll get through these arguments without spending hours and hours doing what we ought not to. Because I have read the paper. So just refer me to the points you want particular attention to. You know, something that you want to highlight, something that you want my attention to, or that you want now to omit from the papers as well. That would be useful.
Yes, I mean, that had my lady. But can I just tell my lady, because I am going to need to refer my lady to certain specific paragraphs of our heads of argument and certain cases that have been uploaded on case lines. Can I just direct my lady's attention to where our heads of argument are? They are at section 054-473.
473. All right. Well, I'm quite sure that Ms. Mashitiso will retrieve it and just email me a copy, because I'm not on case lines. So I'm sure that she will send me a copy so that I will be able to consider it even later today or this evening.
Yes. Okay. As it please the court, my lady. My lady, the first point that we take, my lady, may I ask maybe then that Ms. Mashitisho email you our heads of argument, because I think it will make it much quicker if my lady has a copy of the heads.
Mm-hmm. Yes, I'm sure she'll do that now.
Yes, as it pleases the court, my lady. The first point which we take in this matter, my lady, is the question of jurisdiction. Our submission is that my lady does not have jurisdiction to entertain review applications such as the present. In particular, my lady doesn't have jurisdiction to inquire into the constitutional validity of the conduct of organs of the state, such as the Gauteng Department of Health and the GDID. The first point which we take, and it is a point that has been taken before in this tribunal, and I'll refer my lady to the relevant cases dealing with this. It is the fact that the tribunal is not a court of law. My lady will know that this issue has been raised before, but our submission is that that question has actually not been answered by the previous tribunals, which were specifically asked to deal with this particular question. And I'll refer my lady to the relevant cases in due course. The first point which we make, my lady, is that the SIU Act simply makes provision for the establishment of special tribunals. But it is also specific in the sense that it specifies what the tribunal is established to adjudicate. It is established to adjudicate upon civil proceedings emanating from its investigations and so on and so on. But the approach that seems to have been taken by the SIU all along seems to be that civil proceedings include judicial review proceedings such as the present. And we submit, my lady, that is an incorrect approach. And I will take my lady to the relevant parts of the legislative framework that supports that contention. Next in line, my lady, is the provisions of Section 166 of the Constitution. That is the section which tells us what courts are recognized by the Constitution. And my lady will see in Section 166 of the Constitution that there is no recognition of tribunals. There is only a recognition of the Constitutional Court, the High Court, and courts of a similar status to the High Court and the Magistrate Courts. Those are the only courts that are recognized. And the fact that a tribunal is not mentioned in Section 166, we submit, my lady, it's not a mistake.
What about the other courts? Let me just ask you this.
Yes.
That provision in Section 66, any other court of similar standing which is recognized? Now, they don't mention labor courts, they don't mention competition appeal courts and so on. But if you look at the powers given to the tribunal in the SIU Act, are you still saying that it cannot be interpreted to mean that it has a similar standing as a high court, especially if you look at, for instance, the appeals from the tribunal go to a full court?
Correct.
And in the High Court, a full court only sits on judgments of a single judge of first instance in the High Court. So this is what I sort of need to hear you on. And I know that the tribunal has actually ruled previously that the tribunal is on the same level as the High Court.
Well, yeah, well, my lady, a court like the labor court is a court of more or less the same status as a high court by legislation. But you don't have anything like that in the SIU Act, because the SIU Act simply enables the president to establish the tribunal. The Act itself does not establish a tribunal. And this is the point which we will develop in due course when we address you fully on, amongst others, the provisions of Section 166, subparagraph E in particular. So a court like the Labor Court, as we submit, my lady, it has the same status as the High Court. But a tribunal, for example, the competition tribunal, we have not been able to find anything that suggests that the competition tribunal itself is a tribunal with the status of the High Court. But also, my lady, the competition tribunal is not the only tribunal that exists in this country. There are other tribunals. By way of an example, there is what is referred to as the Water Tribunal. And the Water Tribunal adjudicates disputes arising from the National Water Act and so on and so on. And it sits and it deals with matters just like a high court will deal with matters. But even better, the presiding officer of the Water Tribunal is appointed after consultation or advice of the Judicial Services Commission. But that doesn't then create an opportunity for a conclusion that it is a court of the same status as the High Court. And we will submit, my lady, that the same applies to this tribunal. My lady, Section 34 of the Constitution, it tells us about the right to access to courts and so on, to have disputes resolved by a court or a tribunal. So the Constitution knows right from the beginning that there is a court and a tribunal. And a tribunal that is referred to therein is not a court of the status of a high court. So when one has regard to that, it cannot just be presumed and concluded that this special tribunal has the status of a high court or that it is a court. It is not, we submit, my lady. And if we are right on that, my lady, we'll submit, then that then means that this application has to be dismissed for lack of jurisdiction. Next in line, my lady, we deal with Section 8, subsection 2 of the SIU Act, because that is the section, my lady, that tells you what jurisdiction the tribunal has. So if you're looking for the source of your powers and the source of your jurisdiction, you go to Section 8, subsection 2 of the SIU Act. And that tells you that you have jurisdiction to adjudicate upon any civil proceedings brought to you by the SIU in its own name or on behalf of an organ of the state. And this is where I must now spend a little bit of time telling you why we say that the civil proceedings contemplated in the Act in Section 8.2 do not include judicial review proceedings. And you will find that, my lady, there are regulations which have been promulgated in terms of the SIU Act. We did place them on case lines, and I'm sure my lady has access to the regulations. Mm-hmm. But Regulation 5, my lady, of those regulations, it defines what civil proceedings are, because they're not defined in the Act. Whether or not it was right for the minister to define that in regulations is something else, but there is a definition of it. And in Regulation 5.2, the phrase or the words civil proceedings is defined as follows: wherever they appear in the Act, including in the preamble, they shall include civil proceedings for any relief for the recovery of any damages or losses and the prevention of potential damages or losses which may be suffered by the state. So when you read Regulation 5.2, you don't come out of it with any doubt as to what it means. It is concerned with proceedings for the recovery of damages or losses suffered by the state, or for the prevention of losses or potential losses which may be suffered by the state. So that on its own excludes judicial review proceedings, because ordinarily judicial review proceedings, they are not concerned with the recovery of damages and the recovery of losses or the prevention of losses. But what is more important, my lady, is that right there in Regulation 5.2 of the regulations, it also tells you the format of the civil proceedings that are contemplated therein. It talks about an application for a restraining order, a preservation order application for forfeiture, and recovery of damages, and so on and so on. But in Regulation 5.2, subparagraph E, it talks about a declaratory application or an interdictory application, and so on and so on. And that is where the SIU has taken the view, incorrectly so, my lady, that the declaratory format of the application of proceedings which are referred to in that part of the regulation includes declaration of constitutional invalidity. We submit, my lady, that is completely wrong, because everything else in Regulation 5.2 is dealing with recovery of damages or recovery of losses, not constitutional invalidity. So it can't then be that the declaratory format of proceedings contemplated in 5.2E is now all of a sudden a declaration of constitutional invalidity. That, we submit, my lady, is completely wrong. So then, my lady, the Promotion of Administrative Justice Act, it also deals with one or two issues which are relevant in this case, because in Section 6 of PAJA, it talks about a judicial review proceedings being instituted in a court or a tribunal. So, my lady, when you see the legislature specifically making reference to a court, it doesn't mean that the legislature doesn't know about a tribunal. And Section 6 of PAJA is a classical example of it, because it says you may institute judicial proceedings in a court or a tribunal for judicial review proceedings. But, my lady, the tribunal that is contemplated in that section is not this tribunal. It's a whole different tribunal. This is not a tribunal for that. And why do we say that? Because we say that because the legislature in Section 1 of PAJA has told us what it is referring to. In Section 1 of PAJA, you'll find a definition of a court, and you'll find a definition of a tribunal. A court is defined to mean the Constitutional Court, the High Court, or another court of similar status, or a magistrate court. There is no reference there in that part of the definition to a tribunal. But there's a special place in section 1 of PAJA where there is a definition of a tribunal. And again, this emphasizes the point that the legislature is fully aware of the existence of tribunals. And there it says a tribunal is defined to mean any independent and impartial tribunal established by national legislation for the purpose of judicially reviewing an administrative action in terms of this act. So there you have it. The tribunal that is contemplated in PAJA is one that has been specifically established by national legislation for the purposes of judicial review proceedings in terms of that act. So the SIU tribunal, this special tribunal, as we know it, it has not been established for that purpose. It has been established for civil proceedings as defined in Regulation 5.2 of the regulations. And there, what the Act talks about, the regulation talks about, is recovery proceedings, proceedings to recover damages and losses suffered by the state, and so on and so on. So then my lady, one may then say, well, but the SIU here is also asking for an order in terms of which it recovers some monies which one may say, well, they are losses which the state has suffered. And let's assume that is correct, that the state has suffered a loss or they suffered damages as a result of that. But then you've got to look at how the relief has been formulated. Firstly, they seek the review relief, what we refer to as the review relief. That is the relief to review and set aside the decision to appoint the respondents and to conclude the agreements. That is the primary relief they seek. If they get that relief, only then they can get the repayment relief that they seek or the just and equitable relief that they seek. Why is that so, my lady? That is because Section 172(1) of the Constitution has put up some form of a discipline on how this thing works. And authority for that proposition, my lady, you will find in the Constitutional Court judgment of Bengwenyama versus Ginora Mineral Resources. It is a case which is not necessarily referred to in our heads of argument, but I think you will find it in other respondents' heads of argument. There, Justice Froneman went on along the lines of saying, let me give you guys a lesson on how this thing works. You don't go to the just and equitable relief unless you have made a finding of constitutional invalidity. So your finding of constitutional invalidity is the only road to the just and equitable remedy. So in this case, because we say the tribunal doesn't have jurisdiction to grant the order of constitutional invalidity, it means you can't even go to the second just and equitable remedy because the other first requirement for it is not there. So we submit then on that basis, my lady, that you don't have jurisdiction. But most importantly, my lady, because the SIU comes to you in terms of Section 172(1) of the Constitution. But Section 172(1) of the Constitution, it talks about a court, the powers of a court in constitutional matters. It doesn't talk about the powers of a court or a tribunal in constitutional matters. And again, as I said earlier on, the mere fact that Section 172 talks about the powers of the court and not a tribunal is not a mistake. It is not because somehow the legislature forgot about tribunals. It used the word tribunal in Section 34, so it knew about the existence of tribunals. So when it went to Section 172, it chose specifically, deliberately so, to exclude tribunals in that kind of an question. And a further example to that, my lady, is because not every court, not every tribunal has the jurisdiction to entertain the validity of the conduct of the president or the constitutionality of legislation and so on and so on. So if the argument that this is a court, which we say it is not, it will then mean it can inquire into the conduct of the president. But the Constitution tells you exactly which courts have a jurisdiction to entertain that conduct. It's the High Court. But if you now say this tribunal has the status of the High Court, then it will necessarily mean that it can now inquire into the conduct of the president. And we submit, my lady, that's not correct. It doesn't have that jurisdiction. Then, my lady, the first time or one of the prominent judgments where the tribunal was specifically asked whether or not this is a court is the matter of the Special Investigating Unit versus Lidla Structural Development Pty Ltd. My lady,
versus Lidla.
Lidla, yes, my lady, yes. My lady will find that referred to in paragraph 2.11 of our heads of argument. And there, my lady, the question was asked, specifically and directly so, is this a court? And our submission, my lady, is that, and with greatest of respect, the tribunal did not answer the question. And this is despite the fact that the question was specifically put to it. Are you a court? So, my lady, in paragraph 46 of the judgment, this is what the tribunal said in paragraph 46. It said, the special tribunal is unique and sui generis. The tribunal has a limited jurisdiction over civil disputes arising from investigations conducted by the SIU. So right there, my lady, this tribunal accepted, and correctly so, that it has limited jurisdiction over civil disputes. But then in the very same paragraph, when it was attempting to answer the question, this is what it said. It said it is presided by judicial officers who are empowered to adjudicate in civil disputes and make orders that are binding, and so on and so on. And then it said the following, which is important. It said, it is not named as such, but it performs the functions of a civil court. But when it talks about performing the functions of a civil court, you then just look back at the beginning of that paragraph, where it said, my jurisdiction is limited over civil disputes. So its functions as a civil court, my lady, we submit, it is limited. And we emphasize the point that when it talks about civil disputes and civil proceedings, it is talking about civil disputes as they've been defined in Regulation 5, a sub-regulation 2 of the regulations of the SIU, of the SIU Act. So paragraph 46 doesn't answer the question. Then you go to paragraph 47 of the judgment.
Sorry, paragraph 47.
Paragraph 47 of the
because you're just fading away a little. I think you're moving away from the, yes,
okay,
all right.
Sorry, can my lady hear me now?
Yes, I can.
Yes, so paragraph 47 of the legal judgment, the court continued to try to distinguish the tribunal from commissions and all of that. But then again, the learned judge emphasized that in effect, apart from the fact that it is not named as a court, and this is what the tribunal said. It said, I'm not named as a court in the Constitution. And then he said, and does not have appellate jurisdiction from the magistrate's court. And then he said, it would fit the description of a court as contemplated in section 166E of the Constitution. My lady, that is the best that you will find in that judgment, that everybody now relies upon to contend that the tribunal is a court, simply because it will fit the description of a court. But go to section 166E, my lady, you are not going to find any description of anything that says that the tribunal is a court. And I'll read for you. You'll find this in the judgment itself, because So he said section. Yeah, so section 166E names it only names the various courts. That's what it does. But in E, because they didn't want obviously a situation where they're going to be accused of not making provisions for others, then they say any other courts established or recognized in terms of an act of parliament, including any court of status similar to either the High Court or the Magistrate Court. And then again, my lady, we emphasize, it doesn't say any other court or tribunal. It is limited to courts. It is limited to courts. So we submit, my lady, that paragraph of those two paragraphs of that judgment, my lady, they don't constitute authority for the proposition that this is a court. It is a tribunal, and that is all that it is. The second judgment, my lady, that deals with this, and I think our learned friends rely on this in their heads of argument. It is the Caledon River case, SIU versus Caledon River Properties Pty Ltd. My lady, it's also a judgment that we have uploaded on case lines, and I will ask the registrar, Ms. Mashitisho, to make it available to you.
Yeah, I have it already, thanks.
As it please the court, my lady. So, my lady, one must then go to paragraph 33 of the judgment to see how the tribunal arrived at the conclusion that it is a court. And again, we submit, my lady, that even there, the tribunal did not answer the question with respect. And it is then not authority for the proposition that this is a court. So from paragraph 29 of the judgment, my lady will make a note of this. The question is asked, is the special tribunal a court as referred to in section 166E of the Constitution? And this is the very same question that was asked in the legal judgment. So Her Ladyship, Judge President of the tribunal, then deals with this particular question from paragraphs 33 to 37 or so of the judgment. But paragraph 33 tells you exactly the reasoning that led to this conclusion that suggests that this is a court when it is not a court. So in paragraph 33, my lady, the tribunal said the following. The special tribunal bears the hallmarks of a court endowed with judicial authority as envisaged in section 165 of the Constitution. And then the learned judge said section 165 of the Constitution determines what a court is. It is an institution vested with judicial authority. My lady, we submit that that's not right. In fact, it's the other way around. Because all that section 165 does, my lady, it tells you where judicial authority vests. Section 165(1) says, the judicial authority of the Republic is vested in the courts. It is not vested in the tribunals. That, with respect, my lady, is not a determination of what a court is, as the judgment in Caledon River suggests in paragraph 33. That's not a determination of what a court is. So when you want to know what a court is, you don't go to section 165, because section 65, all that it does, it tells you where judicial authority vests. That's it. So the second point, which is raised in that paragraph, is that the special tribunal bears the hallmarks of a court. And all that it means in simple terms, my lady, is that it looks like a court. It functions like a court. It has been vested with judicial authority. My lady, tribunals like the CCMA, they function like courts. Tribunals like the Water Tribunal, they function like courts. Tribunals like the Competition Tribunal, they function like court. They've been vested with authority by legislation to resolve disputes and so on and so on. We submit, my lady, they are not courts. And my lady, we submit the same applies to the special tribunal. So then, my lady, the last paragraph of the legal judgment to which I must refer you, my lady, is paragraph 50 of that judgment. Because there in that paragraph, the tribunal concluded that the reviewing and setting aside of improper and lawful conduct is competent relief, which the tribunal is able to give. And they said that the reason why they arrived at that conclusion is because they say that that may be sought within the meaning of civil proceedings in the regulations. I've already referred you to the regulations. So the regulations tell you that they are concerned with recovery of damages and losses suffered by the state, or to prevent potential losses to the state. So that, my lady, we submit that that should put an end to any doubt about whether or not the special tribunal is a court. It is not a court. All these two judgments upon which reliance is placed for the contention that this is a court, they have in fact not answered the question. It is not an answer to say it looks like a court, it is a court. An arbitration tribunal looks like a court, it functions like a court, but it is not a court. So on that point, my lady, we submit that this is not a court, and as a result of that, you do not have jurisdiction to entertain the review relief, and the matter will then have to be dismissed simply on that point. But my lady, if you don't agree with us on that point, the second point that we raise is the question of unreasonable delay. We submit that there has been an unreasonable delay in launching these proceedings, and that you will be entitled to dismiss the whole application just because of the delay. I'm aware that there is an argument that says at all material times when you are confronted with a unlawful conduct, you must declare it as such in terms of Section 172(1) of the Constitution. That is a correct proposition, but that is if you even enter the merits of the case. Because it is when you enter the merits of the case that you must now decide whether or not there is a basis to declare conduct as constitutionally invalid. But we say in this case, the delay prevents you from even going into the merits of the case. And I'm going to refer you, my lady, to the Gijima judgment. It's referred to in our heads of argument, and I think other parties have also referred you to it.
Yes, is it in your heads?
Yeah, it is referred to.
Just refer me to that, and it's not necessary to read. If you've got it in your heads, then it's not necessary to read it.
My lady, the part that I'm going to refer you to now is not referred to in our heads of argument, but the case itself is referred to in our heads.
Mm-hmm.
So I'm going to draw your attention, my lady, to paragraph 44 of the Gijima judgment.
Which paragraph of your heads is it referred to?
I will tell you now, my lady. It is referred in various parts. I think from where we deal with. Let me just give you the general reference, my lady, which is paragraph 3 of our heads of argument. That's where we deal with the issue of unreasonable delay. So my lady will find it referred to there. And it is also referred to where we deal with the appropriate relief, which is to be granted.
Yes.
But paragraph 44 of the judgment, my lady, it tells you why it is necessary to bring review applications without undue delay. And the court cited its previous judgment of Justice Cameron in the Mirafong case. My lady again will find it there. There the court said the rule against delay in instituting review exists for good reason, to curb the potential prejudice that will ensue if the lawfulness of the decision remains uncertain. Protracted delays could give rise to calamitous effects, not just for those who rely upon the decision, but also on the decision maker itself. I've already told you, my lady, that The mere fact that my client is cited, just the citing of my client as a respondent in this case, is prejudicial to them. Why is that so? Because allegations of wrongdoing are made in the affidavits of the SIU, and my client is associated with it. So the people who should ordinarily do business with my client, knowing that my client is cited as a respondent in these proceedings, which are never ending, are concerned about whether or not they should deal with my client. They no longer look at my client favorably, simply because they are cited. That is the prejudice which the Mirafong judgment is talking about. And we submit this is equally true in this case. So we submit, my lady, that as far as the delay point, I'm not going to waste a lot of your time, because in paragraph...
If you've dealt with it, yes, as I said, if you've dealt with it in your heads, that's fine, because I know you've, in the application that you brought, you dealt with that quite extensively as well. I've read those papers.
Correct.
And I'm assuming that your heads would follow similarly. So yes, it's not necessary to dwell on it for too long. Yes.
Correct, my lady. Yes. Our heads now tell you what law we rely upon on that. But the point I want to address you now, my lady, is the manner in which the SIU has approached the tribunal, and the manner in which they seek to justify the delay. And you will find that in paragraph 190 of their supplementary affidavit. Because in that paragraph, my lady, they suggest...
Sorry, 190, you said?
190, yes, my lady. Because in that paragraph, my lady, they want to suggest that the clock, or the proverbial clock, as it is referred to in the judgments, started ticking when they came into possession of all the facts relevant to the review. And they said that was roughly 4 months since the knowledge came into their possession. So according to that argument, my lady, the suggestion by the SIU, which we submit is terribly wrong, is that there is a time where the proverbial clock starts ticking, it stops ticking, it waits for the SIU to gather information, and once they've received the information, then it continues to tick again. There's no such. It doesn't work like that. The clock runs continuously from the beginning to the end. It only stops when you bring the application. And we now know, my lady, in this case, that these decisions, which are sought to be reviewed and set aside, they were taken in March and in April 2020. That is common cause. And on the authority of Asla Construction, and my lady, Asla Construction is also referred to as Buffalo City in our learned friends as a fragment. And I'll use Buffalo City from now. So in Buffalo City, the court made it clear that the clock starts ticking from the beginning. So the suggestion by the SIU that the clock started ticking when they received all the relevant facts to the review, we submit is wrong. But there's also another point which contradicts or destroys their argument. Because if you have regard to the affidavit that was filed for purposes of the preservation order, my lady, a full case for unlawfulness has been made in that affidavit. A full case for these decisions being unlawful has been made in that affidavit. That's why they got preservation orders. So this further delay in bringing the review application because some facts were not available, we submit, my lady, is completely wrong. And it is the same as what happened in the engineered system solutions case, to which I'll refer you earlier, my lady. So, my lady, you will find in our heads of argument reference to a Asla Construction, that is the Buffalo City case. It tells you how you should look at the question of delay. You must look at whether or not there's an explanation. And if there is an explanation, you must ask yourself whether or not the explanation is reasonable and all of that. But most importantly, my lady, you must look at the prejudice to the respondents, such as my clients, and then decide whether, in the light of the prejudice, which continues to be suffered by, amongst others, my clients, you should entertain this matter. And we submit, my lady, that when you have regard to all of that, the delay ought not to be condoned. But there's also another important reason, and it is that the SIU itself does not concede that there has been a delay. And on their version that there's not been a delay, they are not asking you to overlook the delay. So you can't overlook the delay if they're not asking you to do it. And they're not asking you to overlook the delay because they say there was no delay. They say we came on time. But that is clearly wrong on the facts. Because you heard from our learned friend yesterday that they're bringing the application on their own, and they're also bringing it partly on behalf of GDOH and GDID. It's a point that I will address you on fully in due course. But on the basis of what we have put up in our heads of argument, my lady, we submit that the delay is unreasonable, and there is absolutely no factual and legal basis for you to condone it. Then, my lady, I'm going to refer you to Section 195 of the Constitution, because that section...
Sorry, just give me a moment.
Sorry, my lady.
Sorry, you may continue. 185 of the Constitution? Sorry,
my lady, 195.
195.
Yes. So Section 195, my lady, says that constitutional obligations must be performed without undue delay. So there is an obligation on organs of the state to bring review applications such as the present. That obligation in terms of Section 195 must be brought expeditiously. It must be brought without undue delay. The SIU doesn't say that they could not have done this unless, until the president issued a proclamation for them to investigate and all of that and all of that. Well, my lady, they don't say that. But I can tell you now that there's an answer even to that. The president himself is an organ of the state. He must act without undue delay in terms of Section 195. And to the extent that reliance may be placed on the fact that there was no proclamation, there was no investigation, they couldn't come to court and so on and so on, it gets defeated by that point. Because everybody, every organ of the state, including the president, must act expeditiously without undue delay. So we submit, my lady, that on the basis of what we have set out in paragraph 3 of our heads of argument, the delay is unreasonable. Lastly, my lady, on the delay point, I think I made a reference to a case called Engineered Systems Solutions. A lady will find it referred, I think, for the first time in our heads of argument in paragraph 3.17. There, my lady, the SIU ran into difficulties. The same kind of difficulties that it has in this case. But for purposes of now, the delay point. Because in that case, they were dealing with, it was an appeal in the Supreme Court of Appeal. And the SIU was heavily criticized because it had no evidence whatsoever from the other organs of the state that it was acting for the Department of Correctional Services, if I'm not mistaken. So there, my lady, the Supreme Court of Appeal said that it was crucial to have witnesses within the department to depose to the events that occurred before and after the SIU's involvement in its affairs. And this is very important for two reasons. Firstly, because you don't know why the departments themselves did not act. And that is important as part of explaining the delay. But secondly, in the SIU's affidavits, allegations of wrongdoing are made against certain officials of the government. Allegations of misrepresentation are made. Allegations of acting unlawfully are made. And there is no version. But the Supreme Court of Appeal there in Engineered System Solutions said the department had a duty to explain its actions and those of its officials. You don't have that. And in this case, you have heard about the non-joinder point, that certain people should have been joined, they have not been joined. But what the tribunal needs to take into account as far as this issue is concerned, and I'll address it very briefly now, is the prejudice which is going to be suffered by these state officials who have not been joined in these proceedings. I'll refer you in later on to a paragraph where the SIU says the misrepresentations were made by these people. The misrepresentations were made by this and that. But if you were to make a finding in your judgment that indeed these officials misrepresented the facts, that is going to be prejudicial to them. That is going to have a negative impact on them. Forget about the order that is being asked of you now. That is going to cause prejudice to them. You can imagine my lady, one of the state officials is a legal advisor who in due course may want to apply for admission as an advocate or an attorney. And when that happens, a judgment is pulled out, which says, you misrepresented facts. You lied. Right there, there's prejudice. But that's not the only example one can give. Generally, it will cause prejudice if findings like those are to be made without those state officials having been cited and having been given an opportunity to file an affidavit. That is why there's an outcry from some of my learned friends that perhaps this should have been done by way of an action. We could have subpoenaed them. We could have called them to come and talk. But we can't do them. We can't do that in proceedings like this. So on that basis, my lady, we submit without any explanation from the department as to what it did before and after the involvement of the SIU. The delay has not been explained, and we submit that on the basis of the delay alone, you are perfectly empowered to refuse to entertain the merits of the review and then dismiss the application. The next point, my lady, deals with the application of the Promotion of Administrative Justice Act. We submit that PAJA applies and that, in fact, the SIU ought to have approached the court in terms of PAJA. But as we know it, the SIU said this is a legality review. They say this is a self-review, and we submit, my lady, that that is completely wrong. The correct position is that this is a review that should have been brought in terms of PAJA. When
just a minute, sorry, just give me a minute, please.
Sorry, my lady.
Thank you.
So, my lady, the point we make here is that the SIU comes to court under the principle of legality. They say this is a legality review. And we submit that this is not a legality review. And in their answering affidavit, my lady, to our application, they make reference to two cases, Patalizi and MEC for Treasury in the Free State. And there again, my lady, I am going to spend a little bit of time because this is very important for my client. We deal with this in paragraph 4 of our heads of argument. And the cases that upon which the SIU relies are dealt with from paragraph 4.2 and 4.3 of our heads of argument. And we submit with respect that once again, these two judgments, they are either clearly wrong or they did not answer the question. On both versions, even if they are clearly wrong or they didn't answer the question, my lady is perfectly entitled to walk away from them. The first judgment, my lady, is Patalizi. And the relevant paragraph in Patalizi is paragraph 11 of the judgment. And again, my lady, this is what the tribunal said. It said, on the authority of Gijima, as applied in MEC for Department of Treasury, Free State Province, this review is akin to a self-review. Therefore, Paja is incompetent under the present circumstances. So the conclusion there is that it looks like a self-review. Therefore, it is a self-review. My lady, we submit that is completely wrong. Again, in MEC for Treasury of Free State, the relevant paragraph there is paragraph 33 of that judgment, and my lady will find that in our argument as well. There, the tribunal said this is the case in the present proceeding. The SIU is not seeking to vindicate any right to administrative justice. As already mentioned, it only seeks relief in terms of section 172, 1A and B of the Constitution. And then they say this is the relief to which the departments will be entitled had they brought the review application themselves. And the important part, the present proceedings are therefore akin to a self-review as referenced to by the Constitutional Court in Gijima. For the same reason set out in Gijima, a review in terms of Paja is incompetent. So, my lady, those two judgments, they rely on Gijima to say that when the SIU brings it as the present, it is akin to a self-review. My lady, Gijima didn't say that. Gijima is not authority for the proposition that this is a self-review. The facts in Gijima, my lady, are very to review and set aside its own administrative action. That there was no any other organ of the state involved in that. And I've already referred you to Gijima, my lady, but you will make a note with respect that paragraph 37 of the Gijima judgment, you will find that there's nothing there that suggests that it is authority for the proposition that when the SIU brings an application such as the present, it amounts to a self-review. So we submit, my lady, that insofar as this is not a self-review application, the SIU ought to have come to court in terms of PAJA, and they will have had to comply with the strict timeframes contemplated in PAJA. In fact, as the delay point would have been raised, they would then have had to bring an application in terms of Section 9 of PAJA, which they didn't have to do if they were coming in terms of the principle of legality. The next case, my lady, which is directly on point in this matter, is a case called CompCare Wellness Medical Scheme versus the Registrar of Medical Schemes. And this is a Supreme Court of Appeal decision. My lady will find that in paragraph 4.14 of our heads of argument. But my lady, before I deal with that judgment, it is better to first give a little bit of context as far as the SIU is concerned. We all know that it was created by the SIU Act. And then the same act makes provision for the establishment of the tribunal. But one must look at the purpose of establishing the SIU and the SIU tribunal, in particular the SIU in this case. The preamble to the SIU Act will tell you that it was established for the purpose of investigating serious malpractices or maladministration in connection with the administration of state institutions, state assets, and public money, as well as any conduct which may seriously harm the interests of the public, and of instituting and conducting civil proceedings in a court of law or a special tribunal. We submit, my lady, that when you have regard to the purpose for which it was established, which on a clean reading of the preamble and Section 2 itself, and Section 4 as well, it is to prevent serious harm to the interests of the public. That is why it was established. The SIU was not established for the benefit of it for itself. It was established to serve the interests of the public. And that, my lady, justifies the submission that all that the SIU does, it does that in the public interest and for the benefit of the public. And there are so many references in the Act itself to the interests of the public and so on, which emphasizes the point. But in particular, you'll find in Section 4, subsection 2 of the SIU Act, where it says that after the SIU has obtained evidence after its investigation, it must inform the relevant prosecuting authority, whereupon such evidence must be dealt with in the manner which best serves the interests of the public. That's another indication. Section 2, subsection 2 tells you the same. When a proclamation is issued by the president, even the proclamation upon which the SIU relies in this very case, it is for them to investigate unlawful or improper conduct which has caused or may cause serious harm to the interests of the public. So, my lady, we submit that they do all of these things, not for themselves, but for the public. And this is where the CompCare Wellness Medical Scheme case fits in. Because in CompCare Medical Scheme, the Registrar of Medical Schemes brought an application to review and set aside a decision of the appeal board of the Council for Medical Schemes. It's another body which has been established in terms of the very same legislation which established the Registrar of Medical Schemes. So there, my lady, they made it clear that they're coming here because they've got an obligation to protect the interests of the public. And that's why they said they brought the review. And there, my lady, a question arose, which the Supreme Court of Appeal had to answer, was whether PAJA or the principle of legality applied. And there, my lady, you had the registrar, an organ of the state, bringing an application to review and set aside a decision of another organ of the state, the appeal board, in that case. And there, the Supreme Court of Appeal said, PAJA applies. There is absolutely no factual and legal basis which has been placed before you to create an impression that the SIU is so special that PAJA doesn't apply to it, or that it doesn't have to comply with the strict time requirements of PAJA. And there again, my lady, there was an attempt to rely on Gijima. And as I said earlier on, Gijima was not concerned with a situation like this. And when this issue, and when reliance was sought to be placed on Gijima in the SCA, this is what the SCA said in paragraph 18 of the judgment. It said, in the state information technology case, the Constitutional Court was only concerned with an organ of the state acting in its own interest to review its own decision. And that's the point I made earlier on. So this is supported by the Supreme Court of Appeal in the CompCare case. So it is only when an organ of the state is bringing its own, bringing a review to set aside its own conduct that it must come in terms of the principle of legality. But to put the matter, my lady, to bed, there is a judgment of the Constitutional Court in Hunter versus the Financial Service Sector Conduct Authority. You will find that referred to, my lady, from paragraph 20, from page 24 to 26 of our heads of argument. And it is important that I draw your attention to this particular paragraph where the Constitutional Court said the following: as a general rule, PAJA must therefore apply unless the review is brought by a public functionary in respect of its own unlawful decision. So, according to the Constitutional Court, which is binding, which binds the tribunal, my lady, the general rule is that PAJA applies. And it is only if the public functionary, such as the SIU, is coming to review and set aside its own unlawful decision that PAJA will not apply. There is also another case, my lady, which is not referred to as a argument. It just came to my mind now. But it's a point that we made in our affidavit. My lady will have seen that. Where PAJA applies, a litigant cannot avoid it. And that is the New Clicks judgment. I think it's New Clicks versus the Minister of Health. We'll place it on case lines. So what the Constitutional Court there said is that you must come to court in terms of PAJA. If you don't come in terms of PAJA, you must actually make out a case to show why you say PAJA does not apply. This is the general rule, which Justice Hampepe was talking about in Hunter's case. It is a general rule. And then, lastly, my lady, on this point is the following, which the the Supreme Court of Appeal said in CompCare case. It said when the registrar and the council brought.
So you must tell me if you're referring to your heads, because I don't have. You're not giving me a reference. Is this in your heads?
Yes, this is in our heads of argument, my lady.
What page? What paragraph?
Page 25 of our heads of argument. All of this, my lady, is in paragraph 4 of our heads of argument. But the point I am drawing my lady's special attention to, my lady will find on page 25. It starts at the bottom of page 25 of our heads of argument, and my lady will find it underlined, where the SCA said, when the registrar and the council brought their application in the public interest, and this is what we said the SIU is doing here, they did so in order to safeguard the fundamental right of each member of the public to just administrative action. That being so, they stepped into the shoes of the members of the public on whose behalf they litigated, and in this sense were, despite being organs of the state, bearers of fundamental rights to just administrative action. The PAJA consequently applies to the review of the appeal board's decision. Maled, this is a classical example of what is going on here. And this is a case which we say is directly on point, because this is where one organ of the state was trying to review and set aside a decision of another organ of the state. And the Supreme Court of Appeal said, no, PAJA applies. Because when you do that, you don't do it for yourself. You do it for the public on whose interest you litigate. And this is exactly what we say the SIU is doing in this case. My lady, there is a paragraph in engineered system solutions, because this case also, the issue of the application of PAJA, my lady, also came into play in engineered system solutions. Again, my lady will find this in our heads of argument. But the reason why this is so important for me to refer my lady to is because there is a paragraph in engineered system solutions which is favorable to the SIU in this case. But I must tell you why you should not follow that paragraph. This is dealt with in paragraph 4.16 of our heads of argument. With respect, we'll ask my lady to make a note of that paragraph 4.16 of our heads of argument. Because in that case, the SIU and the Department of Correctional Services, they were all applicants. They were acting together, unlike in this case. They sought to appeal against the decision to dismiss their review application. So when the matter came to court, the application of PAJA became an issue. And again, the Supreme Court of Appeal there, it didn't answer the question, but it relied on Gijima, where the Constitutional Court said that what was before it had nothing to do with a scenario where an organ of the state that is in a position akin to that of a private person may be seeking to review the decision of another organ of the state. So what the court was saying there is that it's the direct opposite of what was said in CompCare, because in CompCare said, if you are acting for the public, for the benefit of the public, in the interest of the public, you actually step into the shoes of members of the public. And when you do that, you must use PAJA because you're acting on their behalf. But in engineered system solutions, the court said, but this is not such a situation. And this is what it said in paragraph 25 of the judgment. It said, although the scenario seemed to have been left open by the Constitutional Court in Gijima, it seems doubtful that the SIU will be regarded as being in a position akin to that of a private person. So there, the Supreme Court of Appeal said, well, but this is not such a situation where you can compare it with a private person. And this is why we raised this specifically, my lord. But my lady, when you read engineered system solutions. And this is now the answer to that point. My lady will find it at paragraph 4.17 of our heads of argument. There, my lady, we say an analysis of the engineered system solutions judgment shows that the case was not argued on the basis that the SIU brought proceedings such as the present, not for its own benefit, but for the benefit of the public and in the public interest. So the point that we are arguing before you today, it was not argued in engineered system solutions. So engineered system solutions cannot then be authority to check out our argument on this point, because that point was not argued before the court. But this point is now squarely before you, my lady, and my lady will submit that you are at large to deal with this particular point correctly. And we submit, my lady, that our argument in paragraph 4.17 of our heads of argument is perfectly supported by CompCare Wellness Medical Scheme judgment and the Hunter judgment, which you will also find in our heads of argument. So, my lady, we now deal with the review relief. That, my lady, you will find in paragraph 5 of our heads of argument. Sorry, my lady, I don't know if my lady requires to take a break, but I do think I should be. Sorry, my lady.
We are 20 minutes away from lunch. Are you going to finish your arguments by 1 o'clock?
Well, my lady, that's exactly what I wanted to say, that I think I should be able to finish by 1 o'clock or latest 1:05.
That's fine. Please go ahead.
Thank you, my lady. So the next point then, my lady, is the review relief. And we deal with that, my lady, in paragraph 5 of our heads of argument. The starting point, as far as that is concerned, my lady, is the fact that the SIU obviously comes in terms of section 4.1c of read with section 5.5 of the SIU Act, and so on and so. So we've dealt with that, my lady, from paragraphs 5.1 to 5.3 of our heads of argument. But what we then say, my lady, is that the circumstances which led to this dispute have not been properly articulated by the SIU. And one understands why, because they must now put up a case which is favorable to them and not favorable to the respondents. You have heard from our learned friend, Mr. Arends, that there was no procurement process followed. There was no compliance with section 217 of the Constitution. He said, if you allow this, what are you then going to make out of section 217 of the Constitution? You might as well just throw it out. But, my lady, that we submit with respect is wrong, because a process was followed. And when you find that a process was followed, the suggestion, my lady, that there was no compliance with procurement processes, and that as a result of that, the award of the tenders must be set aside, it must fall flat. The starting point, which my learned friend with respect did refer you to it, is the fact that at some point in time during COVID, the government thought it necessary to procure hospital facilities, and then they started engaging with AngloGold, because AngloGold had a facility that appeared to be available to them. So that, my lady, led to an inspection of the facilities. What then happened, and this is where I don't know whether it is a confusion or what, but there's a suggestion that the cost of refurbishing and renovating the hospital ballooned they went over budget and escalated to 500 million rands. And it is as a result of that. And this is where the sting against the respondents comes from, because an impression is created that there was a proper assessment of the work that needed to be done, and there was a proper conclusion that it will be done by not more than 50 million rands. That's the impression that is created. And the impression is this thing should have cost only 50 million rands because that was the budget. My lady, we submit that again is not correct. And my lady will see in our heads of argument that there was a site visit to inspect the facilities on the 16th of March, 2020. The following day, but maybe before you even go to the following day, you will see in the documents to which we have referred you, the people who went to conduct the site inspection. They were just bureaucrats. They were government officials. No suggestion is made that they were experts in conducting the assessment which they did to come back to say it will cost an estimated 50 million rands. Nothing of that sort is said in the papers. But the following day, on the 17th of March, there is a memorandum that is issued that suggested that all of the work that needed to be done will just be minor repairs. That's what they said. Only minor repairs will be required. Estimation, 50 million rands. No one knows where that comes from, because the people who are writing this memoranda are not even qualified as experts from the papers that have been filed of record. But one sees, when one looks at the chronological sequence of events based on the documents to which we have referred you in our heads of argument, is that from the time that they now started saying this is something which we want to do, and when a proper analysis is now done of what works needed to be done, the position started changing. All of a sudden, they are paying particular attention to this. They are now realizing that actual serious major refurbishments are required. But with respect, these important allegations which are contained in the documents, they are not highlighted by the SIU as much as the fact that the cost ballooned to 500 million. But the point is, there was a point in time where they departed from minor repairs to major refurbishments. But not only that, installation of equipment. The existing theaters had to be rearranged. ICU facilities had to be put in place. And you will find the reference to these documents in our heads of argument.
Where?
In our heads of argument, my lady.
Where, which paragraph?
Paragraph 5. All of this, my lady, is in paragraph 5. And it's subparagraphs. So there, my lady, you will see when you go through the documents to which we refer you that as time went on, they are now seeing that more work is required. Then, my lady, once they had come to that realization, that is when they appointed experts and all of that. But before they appointed the experts, my lady, there was a memorandum which is important, and my lady will find the reference to it in our heads of argument. Because what happened there is the head of department or the accounting authority or the accounting officer of the department, he was asked, can we procure these services on an emergency basis. So there, my lady, the approval was given that you can procure on an emergency basis. And my lady will know that when these events were unfolding, the country was just about to go on a hard lockdown. And the country was locked down immediately after that. But before the lockdown, it is taken by the relevant that we say in our heads of argument, my lady, that is the decision which gave birth to the appointment of, amongst others, the seventh respondent. Everybody else here was appointed in terms of that decision. When the officials of government telephoned the respondents to say, can you do this work? They were acting on the basis that there was authority empowering them to deviate from a competitive bidding process, because you don't follow that process in an emergency situation. But my learned friend for the SIU repeatedly said there was no competitive process. He said, even in an emergency situation, you must still follow a competitive process. Where is the authority for that? How on earth could you be exempted from following a competitive process, but you must still be required to follow a competitive process? We submit, my lady, it doesn't work like that. Either you have an exemption or you don't have an exemption. In this case, there was an exemption that had been given. They were given authority to procure on an emergency basis. And that decision, it still stands today as we speak. They don't seek to review and set it aside. How on earth then do you go and set aside a decision which was done pursuant to a decision which remains standing? It will make a mockery of judicial review proceedings. Because on the one hand, you are saying there was no authority to do it. But on the other hand, we know from the record that there was a decision to approve procurement in this fashion. So we submit, my lady, that without that decision first having been set aside, it is not competent for the SIU to get any of the relief which it seeks. But it is even more concerning for my clients, because after all of this had been done, they were made to conclude a service level agreement with the department. I'm going to refer you, my lady, to paragraph 5.11 of our heads of argument. My lady will make a note of that. But that paragraph, my lady, deals with clause 4 of the service level agreement concluded with my client. And I'm going to read for you what it said. That the person who signed the agreement said that they had full power to enter into and perform in terms of this agreement. They have taken and shall take all necessary action to authorize the transaction hereunder, and all authorizations and approvals required or advisable in connection with the entering into performance, validity and enforceability of the agreement had been done, and they said they are in full force and effect. When they said that, They were talking about the decision that I told you just now, that there was authority given to deviate from a competitive bidding process. They were relying on it. And even today, my lady, that authority is not being challenged in these proceedings. It remains standing and it is of full force and effect. So even if that authority may have been unlawful, it has consequences which cannot be ignored. That is what Odekral and everybody else who followed Odekral will tell you. You must first set it aside if you want to benefit from the argument which the SIU is now making. But my lady, there is an answer to what the SIU is trying to do in this case. In Gijima, my lady, Gijima had given this kind of assurances, and my lady, you will find that even quoted in paragraph 6 of the Gijima judgment. I think the government, everywhere, they use the same template for these agreements, because even there was a provision that says exactly what is in the GDID agreement. Exactly the same. We assure you, we have complied with everything. We have followed processes. We have been authorized to do what we are doing. That's what was said there. But what we now know from Gijima, that was not correct because there wasn't such authority. And in dealing with the question of remedy, this is what the Constitutional Court said. It said, I accept CITA's contention that the agreement is constitutionally invalid. But it starts and stops there. The agreement is invalid.
So you're reading from which? From Gijima?
Yeah, from Gijima, yes. It said, it starts from there, the agreement is invalid. This is what it said. In the circumstances, a just and equitable remedy is that the award of the contract and the subsequent decisions to extend it be declared invalid, with a rider that the declaration of invalidity must not have the effect of divesting Gijima of rights to which, but for the declaration of invalidity, it might have been entitled. So, why did it do that? For two reasons. It said you gave them an assurance that you were authorized to conclude the agreement. And secondly, it said you unreasonably delayed coming to court. That is why the Constitutional Court gave that rider, and my lady will find that at paragraph 54 of the Gijima judgment.
Sorry, what paragraph? 34?
54, 54 of Gijima. And my lady will find in paragraph 6 that the exact clause in Gijima, you will find it in clause 4 of my client's agreement with the government respondents in this case. And there's absolutely no reason why you should not follow the same path which was followed in Gijima. Because in Gijima, the declaration of invalidity was granted. But the court said, I'm not going to deprive Gijima of the benefits it became entitled to in terms of the agreement for two reasons. One, you misrepresented the facts. You said you were authorized when you were not authorized. You gave them assurances. And secondly, it said you did not explain the delay. These are the complaints in this case. There is unreasonable delay, and they gave us these assurances. My learned friend said that we were raising a stopper. We are not raising a stopper. We are saying these issues are relevant when you consider what just and equitable remedy you must give. And when you take all of these issues into account, there is absolutely no reason why the SIU and the government respondents should benefit from these issues. Then I must refer you specifically now to paragraph 5.14 of our heads of argument. This is where we refer you to paragraph 116.3 of the SIU supplementary funding affidavit.
Just give me a minute.
Yes, my lady.
To the founding or supplementary funding?
Supplementary funding affidavit, 116 of that affidavit. We deal with that, my lady, in paragraph 5.14 of our heads of argument. And there we say, the SIU correctly accepts that material misrepresentations were made by those present at the site inspection to the persons responsible for approving the expenditure concerned and general good condition of the premises forming the subject matter of this application. But what is more important there, my lady, they talk about approving the expenditure concerned. On their version, the approval of this expenditure was granted. How can they now come and argue that all of this was not authorized? But at the same time, they say the people who approved the expenditure did that because facts were misrepresented to them. It cannot be right. So, if that approval was based on misrepresentation, they must first set it aside. And only after they have done that, they can then say the subsequent transactions were unauthorized and they must be set aside. They're not doing that.
So which decision you say must first be set aside?
The decision to approve this procurement, the decision to approve this expenditure, those decisions must first be set aside because the people who acted, in this case, they acted on the basis of that authority. They were relying on that authority. Even clause 4 of my client's service level agreement is referring to that very same authority. That's why they said we have authority to do what we are doing. They were relying on that. But the SIU doesn't seek to set that aside. But what is also important, my lady, is also that the SIU doesn't say that my client misrepresented the facts. So my client here is an innocent bystander in this. And them being innocent bystanders, they are not to be visited with the consequences of setting aside the agreement, setting aside the decision to appoint them, and there is no basis why they should be made to repay the monies which have been paid to them. Lastly, on this point, my lady, we deal with what we say is the approach to irregularities. My lady will find that from paragraph 5.21 of our heads of argument. There are 3 cases that I need to refer my lady to, which I've got no doubt that my lady is fully aware of them. The first case is the all-pay judgment. The second case, my lady, is the Millennium Waste judgment and the Alter case. Millennium Waste, in particular, is critical of setting aside decisions such as the present. It says you must be careful not to take decisions which will instead create the potential for loss and chaotic disruption. And then All-Pay said that the potential practical difficulties that may flow from declaring the administrative action constitutionally invalid must be dealt with under the just and equitable remedies as we said previously. So if you declare this thing invalid, then we say the just and equitable remedy must be the one that was given in the Gijima case because of the assurances that they were authorized when, according to the SIU, they are not authorized and all of that. And then the Altec case, my lady Altec versus the city of Pretoria, you will also find it in our heads of argument, paragraph 5.26. This is where the court said that there will seldom be a procurement process entirely without any flaw, but perfection is not demanded. And not every flaw is fatal, nor does every flaw in a tender process amount to an irregularity, much less a material irregularity. Public contracts do not fall to be invalidated for immaterial or inconsequential irregularities. Indeed, as it has been put, not every slip in the administration of tenders is necessarily to be visited by judicial sanction. This, my lady, we submit equally applies in this case. More so because the original decision to procure in this manner is not sought to be set aside. My lady doesn't know why the government took the decision which they took. My lady doesn't even have the record of that decision. My lady is not being told why the government acted incorrectly. All that my lady is told now is that there was no competitive bidding process that was followed. This was irrational. And that is in relation to the appointment of the respondents. It's not in relation to the authority in terms of which they were appointed. So we submit then, my lady, that on the basis of these authorities, my lady ought not to set aside the decision, or at least the agreements which my clients concluded with the government. My lady, from paragraph 5.34, we have extensively dealt with the issue of the just and equitable remedy. We have given you a long list of issues which we say my lady must take into account. We have referred you again to the Altec case because it carefully deals with this particular issue of just and equitable remedy. We have dealt with, in paragraph 5.36 of the heads of argument, we have also dealt with additional issues which we say my lady should take into account. I'm not going to give you a long list of they are all there in our heads of argument. The last point, my lady, is in paragraph 6 of our heads of argument. I'm not even going to be 5 minutes on this. That is the issue dealing with the admission of our supplementary answering affidavit, my lady. My lady, you have said you have read the papers in that application. We submit, my lady, that a proper explanation for the late filing of the answering affidavit has been provided. My clients were represented by other attorneys and other counsel previously. We were briefed at some point once all these papers had been filed. My lady will appreciate the voluminous nature of these papers. And we did need time to go through the papers. And having done that, we realized that some of these law points had not been taken in the answering affidavit. And we then advised that a supplementary answering affidavit should be filed. And it has now been filed. My lady, the leading authority on this point is a case which you will find in paragraph 6.7 of our heads of argument. That is the Transvaal Racing Club versus Jockey Club of South Africa. There, my lady, the court held that if there is an explanation which negatives malafides or culpable remissness as the cause of the facts or information not being put before the court at an earlier stage, the court should incline towards allowing the affidavit to be filed. So, my lady, we submit that There is no mala fide here. There is no culpable remissness. These points were raised by us as the new legal representatives of the seventh respondent. We saw
so
that
it was a legal representative point, not a party point then.
Yes, my lady. So we then said, well, but you haven't raised these law points. And then we then filed a supplementary affidavit to then raise the issues. So the suggestion by the SIU that these issues were deliberately held back by my client is not supported by any evidence, my lady. And the last case to which we referred you to, my lady, is the case of Brody versus Maposa. Is one of the recent cases that you will find referred to in our heads of argument on this point. You'll find that at paragraph 6.9 of our heads of argument. There again, my lady, the court followed a Transvaal Racing Club point case where it said that unless there's mala fides and culpable remissness, then the affidavit should be allowed. And lastly, on this point, my lady, the SIU has fully answered everything in that supplementary answering affidavit. They have they've answered the application itself, and they've answered the supplementary answering affidavit itself, and we have replied to it, and they have argued the law issues which have been raised in that affidavit. So we submit, my lady, that on that basis, there is no prejudice whatsoever. The SIU has fully argued its case. They will be entitled to reply to whatever issues they want to reply to arising from that affidavit when they reply. And the matter did not have to stand down. The matter did not have to be postponed for the SIU to deal with these issues. So there's no prejudice to the tribunal. There's no prejudice to anybody. And we submit, my lady, that a proper case has been made by my client for that affidavit to be allowed. My lady, there's just one point I just want to see. Okay. So my junior just referred me to a particular page, but I think I've dealt with it already. So, my lady, for all these reasons, we submit that the application, the review application should be dismissed with costs for the reasons which we have set out in our heads of argument, and that the cost should include the cost of 2 counsel, and our application to file a further affidavit should be admitted, and that the cost of that, my lady, should be cost in the application. So those are our submissions, my lady.
Thank you, Mr. Saxtwana, for finishing, albeit 5-6 minutes later.
Yes.
But that's the end of your submissions.
I tendered the cost for the 5 minutes, my lady.
For the 5 minutes. Okay, we will have to draw a bill of costs for that.
Yes, I'm indebted, my lady, for
you must realize it's a serious matter to keep people, and especially the council who've been sitting all day from their lunch for 10 minutes. So
yes,
you could incur substantial costs.
Yes, my lady.
All right, good. Thank you. We'll take the lunch adjournment now and resume at 2.
As it pleases the court, my lady.
Thank you. We adjourn now.
That you
Okay, I had my mic on mute, sorry. Is everybody present now?
Present, my lady.
Thank you. Right. Mr. Hurtis, I think you're up next. You said you will do the 10th and 13th respondents at the same time.
Yes, my lady.
All right. I'm starting to worry about time. There's still a number of you to address. And then, of course, I've got to give Mr. Arons a chance at the end, and he's got to reply to all of the respondents that have argued. So I really think we need to be conscious of time. And I repeat what I said previously, is that what you've got in your heads don't have to be repeated. You could just point my attention to something that you need me to pay particular attention to, or if there's something that's not in the heads that you, for instance, a new case or something that you need to raise. If we could do that, then I think we'll just get through everything fairly quickly.
Thank you, my lady.
Thank you, Mr. Herders.
My lady, at the outset and by way of introduction, I do not intend to repeat anything from my heads. I take them as read, my lady. I also align myself with the argument of Mr. Tatsani, and I won't repeat that which is placed before your ladyship, even though we have a lot of similar arguments. I might amplify some of the points that he's made. My reference, my lady, will be to the papers. I know at the outset it will look like I'm quoting extensively from the papers, but it's not my intention to do so. Later on, we go outside of the papers, my lady, and I assure your ladyship that I'll be done today in the course of this afternoon. My lady, the starting point then is that this is what...
Sorry, Mr. Herders, before you go, we have the other pandemic that's troubling us at the moment, load shedding. So we must bear that in mind. I did not have my laptop on charge, so I'm sitting at about 50% charge at the moment. So I need to be conscious of that as well.
Yes, your ladyship, please.
Thank you.
Lady, the starting point is that we are currently faced with the one application that deals with two types of relief, as Mr. Arons says. The first is to declare the contracts invalid, and the second is to disgorge the profits. Now, this is one application. Both of these types of relief are opposed, and we don't believe that either of them ought to succeed. And even if one does but not the other, there are cost implications for the applicant. That's something that I ask your ladyship to bear in mind. And particularly so, my lady, if we go into the issues here, which came about in a strange turn of events, my lady. Now, my lady, I've been informed during the lunch break that the minutes that were missing from the 11th of February 2002 case management meeting have now been uploaded, my lady. The reference on case lines is 077 at pages 24 to 28. Now, the significance of this, my lady, is it sets the dates of
Give me one moment, Mr. Herders. I just want to write this down. I'm not on case lines, by the way, so I rely on the documents being emailed to me. So just give me one moment.
I work the same way as your ladyship, so I appreciate that. That's why. It's 077. So it's 077 at pages 24 to 28, my lady. Now, the important aspect of that, my lady, is that it's important to note that in relation to this very matter, there was a preservation application that was brought on the 15th of September 2021 to review and to set aside the transactions to recover the monies paid, wherein it was anticipated there would be a dispute of fact. The authority, the reference, my lady, for that is 096-12. So it's section 96, page 12. Now, my lady, that was the starting point, 15 September 2021. As your ladyship knows, and we have it now on the reference that I've referred your ladyship to, there was a case management meeting on the 11th of February 2022. And in that case management meeting, my lady, the main issue that arose, and for which I take the credit, my lady, was that we had not received the expert's report that was the basis of this entire application. And this is evident from page 26 in section 77, my lady, where after the introductory remarks, a timetable was agreed between the parties. And the first issue that arose there, my lady, was the Rule 3512 and applicant's expert report. And the respondents were required to file the Rule 3512 by the 15th of February 2022. And then the applicant was required to file the responses to the Respondents' Rule 3512 by the 8th of March 2022, together with its expert report. So it was known at that stage, my lady, that there was an application for relief to cancel the contracts and to recover monies paid, but no expert report had been made available, even though it's formed the basis of the application. And thereafter, my lady, and it's important that I highlight this, and I'm going to repeat myself on this because it goes to the crux of the matter and the costs, and there's tremendous cost implications. It was then, at that stage, my lady, never envisaged that there'd be an amended notice of motion or a supplementary filing affidavit with different forms of relief. So there was really an application before the court, and it was then a case of tying down the respondents to when they would answer. And they said, we said, we weren't in a position to answer because we did not have the experts' report upon which everything was premised. Now, my lady,
I'm sorry, Mr. Hodes, you're going a little bit too fast for me. I just need to
apologize, my lady.
All right, yes, you may continue.
This point is made, my lady, and I'm going to deal with the 10th and the 13th respondents together, my ladies. It's made by the 10th and the 13th respondents. But to begin with, I don't want to repeat every reference. We drew the papers, they're very similar. You'll find this highlighted, my lady, starting in the case lines 094-3. Under our first preliminary point relating to the material disputes of fact, in paragraph 8, on behalf of the 10th respondent, it stated, and I'm going to read this because it set the basis of my argument. It says, while the SIU initially acknowledged the material disputes of fact by not seeking just and equitable relief in the form of compensation, damages, or the like against the respondents, and merely sought the setting aside of the contract, in its supplementary affidavit, the SIU changed tack by seeking payment against the respondents for what it claims to be the overcharging for works done on or services rendered in connection with the AGA hospital. So there was a change of tack that was never envisaged. We also took the point there, my lady, that formed the basis of our second point, and that was that the primary decision makers concerned had not been joined to the proceedings, and we contend that there's a dispute of fact. So we say in paragraph 11 on 94-4, this dispute must also be seen in the context where the SIU and its founding papers to the preservation application under oath committed to the bringing of a review application where it would seek the setting aside of all of the procurement transactions involving the PSPs and contractors, as well as the second respondent, and the recovery of monies paid to all these persons. So it was envisaged that there's going to be one application, and this is what they're going to be trying to do. Then one of the most significant factors, my lady, is in our paragraph 12, and I'll use this as the basis to distinguish this case from most of the cases that were referred to by the applicants. And that's in this case, my lady, the 10th and the 13th respondents are not alleged to have done anything corrupt or fraudulent. And that's a very, very important distinguishing feature, and I'll refer to other cases to explain why it's so important. So, these contracts from the respondents' perception are not tainted by turpitude. And in paragraph 12, we say, it bears emphasis that the SIU has not demonstrated any alleged corruption or fraud in its papers. Now, my lady, this becomes so important because if we look at the cases, and your ladyship will see that in most instances, in cases involving the SIU, there was some complicity in the fraudulent acts or corruption that gave rise to the contracts that are being sought to set aside by the SIU. And we have the clearest example, if I may refer your ladyship to it. It's been referred to by my learned friends as well. And that's the SIU, National Health Laboratory Service case against Tabiso Hamilton and Ndlovu. And if one looks at paragraph 55 of that judgment under the heading costs, in the third line, it's stated as follows: given the abuse of corporate entities, tender fronting, and fraud it has taken place, a punitive cost order is warranted against Hamilton and Lawvu and the companies he represents. He masterminded the fraudulent procurement scheme and challenged funds deriving from the impugned payments through these companies. So it's clear, and I can show it to you, my lady, in most cases, and that's the problem that the SIU has in this instance. One cannot, with respect, and this is where my colleague, Mr. Tsatsani, said, whilst you can say that no procedure had been followed, it's common cause. There was no need to follow a procedure, so there's nothing to read into it in emergency situations. And I align myself with his arguments in that regard. Another case, my lady, that bears reference on the point that I make at the moment, but a somewhat different point, is the Ledler Structured Development case with the SIU, and that's where it was clear from at paragraphs 31 and 32 that a case must be made out on the founding papers. One cannot subsequently make out a case in reply and then rely on that case when one comes to arguing the matter. So, my lady, what we're saying in this case is that a proper case was not made out in the founding papers, even if regard is had to the supplementary founding affidavit and the amended notice of motion. And this is...
Sorry, I didn't get that point. You say they cannot place reliance on the supplementary affidavit.
No, my lady, I never said that. I said a proper case was not made out in the founding papers, including the amended notice of motion and the supplementary founding affidavit for the relief sought. And I'll explain myself as we develop that argument, my lady.
Just a minute. Mm-hmm. Yes, you may continue.
Importantly, my lady, we set out the background, and as I said, I'm not going to read it in great detail. On page 94-5, paragraphs 12 to 16, we explain how the cause of action changed, and it was never ever intended that there would be a case for just and equitable relief until subsequent to the receipt of the report and thereafter the supplementary affidavit and amended notice of motion were filed. And we say that these introduced a new cause of action relating to overpayment, and on account of that, my lady, material disputes of fact arose. And I can say it up front, my lady, and explain myself very clearly, more especially on behalf of the 10th respondent who has filed an expert report. And it begs the question, my lady, and I will give you the references in due course. The applicant has an expert report saying the damages suffered on account of the work done by the 10th respondent amount to a certain amount. The expert on behalf of the 10th respondent gives a different amount. How does this court then decide this on the papers? It's absolutely impossible, my lady. If we were in a trial with an exchange of expert reports, then one would expect that the experts would get together where possible and provide joint minutes. We'd have a case management meetings that would resolve these issues to the extent that they could be resolved. But if they remained irresoluble in the trial, people would testify and be cross-examined. On these papers, my lady, with respect, they remain irresoluble. And it's because the applicant filed an expert report, the 10th respondent filed a counter report, and then the applicant didn't file an expert report, even though they take issue with all of the respondents having not filed expert reports. They say they're only going to answer the expert report and attach a confirmatory affidavit of their expert. But I will show your ladyship that on their own version, they didn't have sufficient particularity to do so, and they didn't have access to papers on their own version for this matter to be resolved and decided on the papers, my lady. We say it's unfair to even expect your ladyship to resolve both of these types of relief on these papers. In fact, we say it's not possible. So, my lady, I was at page 94-6, where we say that there is a lot of hearsay evidence that's been adduced here, and there are inaccuracy, and it's common cause that there's a paucity of documents, and on the applicant's version, this is caused by the uncooperativeness or inability of government officials to provide documents. We also have already alluded to the fact that we say that there's a material non-joinder of the officials that are important. And we don't believe that the issue of overcharging and the determination of the amount due can ever be resolved on the papers, my lady. Issue is taken, my lady, with the Matara report. We say it's inaccurate. This is in paragraph 21, my lady, on 94-7. It lacks credibility.
Just a minute, just hold on.
As your ladyship pleases. I'll repeat, my lady, it was paragraph 21 on page 94-7.
Yes.
And we say the Matara report is inaccurate, lacks all credibility, is not objective, and was prepared pursuant to a mandate from the SIU, particularly concerning issues not borne out by the objective facts. So it cannot be relied upon, and it substantiates the allegation of material disputes of fact. And that's then expanded upon in the next paragraph on that page, my lady, where we say the 10th respondent has adjudication awards for an amount of approximately 17.8 million rand, plus VAT in its favour. And the expert report demonstrates additional claims for 2.5 million rand relating to escalations and 8.5 million rand for work done, measured but not certified and not paid. That's in paragraph 22, my lady. So we say that, and we make the point, my lady, that the 10th respondent can account for every cent of expenditure with a reasonable and market-related profit. And that becomes important, my lady, because it's not the case, and I'll refer your ladyship when I conclude, to cases where one can order the return of items against the repayment of the money in respect thereof, as we see with a few cases dealing with the COVID-19 pandemic, where PPEs are returned and the amount must then be refunded. It's not the case here, my lady. Equipment was supplied, work was done, services were supplied, and one cannot just return them and say, well, we can restore the position to where it was previously, and then we can all go forward from there. It doesn't. It's not a possibility. It's practically impossible. We've explained, my lady, the importance of the decision makers and the government officials who are now being blamed for having entered into these contracts to have been joined to these papers, that they could at least give their view. And even if, as the other cases say, they were disbelieved or they couldn't provide an answer, it would speak volumes as opposed to their silence and exclusion from the process at the moment. And we've set them out, my lady, in the paragraphs 32 and onwards. So we've identified in particular, my lady, two people that we believe were extremely important. It goes back to the earlier argument. In paragraph 32, we explained the lease agreement was signed by Mr. Richard Makumisani, the erstwhile acting head of department of the GDRD. And he also approved the appointment of the PSPs and contractors. And we say, according to section 36.2 of the PFMA, the head of department must be the accounting officer for the department, and that he was the very person that was authorized by law in terms of the statute, being the PFMA, to sign these contracts. So we say he was a crucial participant, or at the very least, a party with a substantial interest in the matter. The second person that we identify, my lady, is Professor Nkulululi Lukele, who is the accounting officer of the GDOH. This is set out, my lady, in paragraphs 36 and 37 on page 94-10. We also, my lady, at 94-13 from paragraph 50, identify Mr. Trevor Tabani, the erstwhile head of supply chain management at the GDRD and acting chief financial officer, who was responsible for the appointments as a party with a substantial legal interest in the matter. And we say that these people, and we identified 10, but these three in particular had a direct interest and a substantial interest in the matter. We then, my lady, at 94-15 from paragraph 63, explain how the contract came about. And this was touched on by Mr. Tsatsani, so I'm not going to repeat, but the important aspect, my lady, is that on the 25th of March 2020, the 10th respondent received an email from Mr. Andy Maluleke confirming the GDRD's intention to appoint the 10th respondent to render certain services. The email encloses an appointment letter signed by Mr. Tabani in his capacity as acting chief financial officer. So to answer Mr. Orense, from our perspective, my lady, everything seemed, for want of a better term, legit or in order. There was nothing that indicated that there was anything untoward or anything wrong here. And we explained that it was then accepted and the contract was signed and then the work commenced. And I stressed, my lady, on an urgent basis in a pandemic. We then turned, my lady, at 94-26 to deal with the Matara report from paragraph 87 onwards. And what we say, my lady, and it goes back to the time frame that I sketched for your ladyship at the outset, is that the Matara report must be seen in its proper context, and we say with respect, as a rushed job which lacks credibility and conclusive findings. And we say that, my lady, because your ladyship is aware that it wasn't available to us at the time, and then it came about at a later stage under tremendous time constraints when the matter was ready before the court, my lady. And then we turn to the fact that that the 10th respondent provided an expert report. Your ladyship will find this at 94-28, paragraph 98. We say that the 10th respondent appointed Mr. Dave Mark Buchanan Stewart, thereafter referred to as Mr. Stewart, and we explain that he's the director of Abacus Construction Cost Consultants Pty Limited. As the expert, he has over 35 years of experience in the measurement and valuation of work for engineering, mining and construction contracts. He also has extensive experience in preparation and quantification of contractual claims, and his report is then attached. And my lady, it's important that I point out to your ladyship that this is merely noted by the applicant. They don't take issue with his experience or qualifications. So to use the illustration that they use, well, there's nothing to negate what he says. So your ladyship is obliged, even in circumstances where we don't have an onus, to accept what he says because they don't dispute his qualifications and experience. They have comments to make in relation to his findings, but they don't substantiate them with a report to show that it's incorrect, whereas he went through the Matara report and he recalculated and explained why he disagreed with this. And your ladyship will find this in paragraph 100 and the sub-paragraphs thereafter. And at 100.4, he calculated, and the 10th respondent pointed out that the profit margin on the contract was 12.13%. So, my lady, that goes against any allegation that there was malfeasance, corruption, or fraud in this matter, because I'm unaware, my lady, of people that commit crimes or fraud to make a profit of 12.13% in situations like this, where he, so to speak, had a captive audience. We also have in 100.5, where he explains that the Matara report's calculation of the 10th respondent overcharged an amount of 34 million. We say that the quantum methodology is flawed, and then the basis, my lady, is set out in great detail. And your ladyship will remember that when the applicant argued, they never ever took issue with any of this. So they say, and in fact, they pointed out that it was the 10th respondent and they said the 11th as well, who were the only ones that put up substantive experts' reports that contradict or differ from their experts' report. At 105, my lady, because this became very important, it stated that in particular the 10th respondent disputes any inference of corruption and overcharging. So we are firmly of the view, or the 10th respondent puts out a case that there is no basis to set aside the agreement, and there's no basis to draw an inference of corruption or overcharging, even if one has regard to the manner in which they were appointed, which is fully set out, my lady, and not disputed, I might point out. The only answer, which I will highlight to your ladyship, is the applicant says, well, we couldn't get our hands on those documents. So, my lady, because you can't find your own companies or your department's draft documents or working documents can never be a basis to set aside a contract with respect. And we, at paragraph 112 on 94-42, the 10th respondent
Just a minute, para 112. What did you say?
Para 112, my lady, on 94-42, the 10th respondent disputes any alleged price inflation. Says the contract was done at a fair price with a fair markup, and that he was there to earn money. He also identifies, my lady, the government official that he believes ought to have been joined to these proceedings at paragraph 137, my lady, on page 94-47. And he says some of the people mentioned there, of the 7 people, may not have a direct and substantial legal interest, but many of them do. And we say at least the 3 that I've already highlighted to your ladyship, who were the procurement officers, accounting officers, and signed the leases on behalf of the departments. My lady, what the 10th respondent concludes in his affidavit appears, my lady, towards the end at page 94-71, paragraphs 233 and 234. It stated the inexplicable contradictions demonstrate that the Matara report is under-researched and inconclusive. Accordingly, the application launched by the SIU is premature and an abusive process at great cost to the taxpaying citizens of the Republic of South Africa. And then at 234 on the same page, my lord, my lady, 94-71, it's noted that the SIU's inability to commit to the relief sought based on its incomplete investigation. Therefore, it's disputed that the relief sought ought to be granted. My lady, that's the affidavit of the 10th respondent. I turn now to only the differences, my lady, I can assure you, I will not be repeating myself, in the 13th respondent's affidavit. Now, the first issue, my lady, in relation to the 13th respondent appears at paragraph 10 at page 96-12. And here, in relation to the material disputes of fact, it's important, and the 13th respondent highlights that on the 15th of September 2021, and that's the application that I referred your ladyship to, there was a preservation application in terms of which the applicant froze funds in the bank accounts of the 6th and 13th respondents. Turning directly to the 13th respondent whom I represent, my lady, the amount of 6,234,365 rand and 26 cents was frozen. So if we round figures, my lady, it's 6.2 million rand that was frozen in the account. And we then, I said I don't want to repeat myself, my lady, so I'm going to just point out that in paragraph 12, it was explained again, my lady, that the SIU in its founding papers for the preservation application under oath committed to instituting a review application wherein it would seek the setting aside of all the procurement transactions and the recovery of the monies paid. So they knew what case they had to meet, and they set it out there. We then highlight to your ladyship in paragraph 18, my lady, bearing in mind that the amount of 6.2 million had been frozen in the bank account on the basis of the application. In paragraph 18, we say that in the supplementary founding affidavit, the SIU only claims an amount of 3,737,505 rand in circumstances where it's holding 6.2 million rand. So you want to set aside a contract claim damages, and you hold a security for your damages nearly, I'm not going to say it is, but close to double the amount. You're fighting over 3.7 million, but you hold 6.2 million rand. And that's never ever alluded to by them in their application, where they had an obligation to place the facts before the court. My lady, the 13th respondent repeats the second preliminary point relating to the material non-joined of the decision makers. I do not intend to repeat what's stated there, my lady, in the interest of saving time. And then they come to a third point, my lady, which is different to the 10th respondent, and that was the point that was also raised by Mr. Tsatsani relating to the delay. In relation to the delay, my lady, we highlight the dates, and my lady, the page reference is 96-25, and the paragraphs that I'm dealing with, my lady, is from paragraph 73 of the 13th respondent's answering affidavit. And the point made there is the review application was not brought within a reasonable time, particularly because on its own version, the GPT was aware of the alleged overspend as early as May 2020, yet the project continued. So in other words, they were aware or believed that there was an overspend, but allowed the project to continue. In addition, Proclamation 23 of 2020 was signed by the President on 23 July 2020. And in paragraph 75, we say, the SIU has not explained as it was required to do every period of the delay up to 12 August 2021, the date that it claims it was aware of the facts necessary to carry out its mandate. Now, it has been referred to by Mr. Tsatsani, and I just want to refer to the judgment that deals with this, my lady, about unreasonable delay. It's the decision, my lady, of SIU versus Engineered Systems Solutions. It's a decision of the Supreme Court of Appeal, 2022, Volume 5, SA 416. And the significant part, my lady, is the concluding 3 paragraphs of the judgment under conclusion. In paragraph 80, my lady, there's a reference to the Altec Radio Holdings case, and there's a quote. In 81, states, in light of the inordinate delay which has not been sufficiently explained, which has been found to be unreasonable, the egregious conduct of the department, the fact that the review application has no merit, the prejudice to be suffered by other contracting parties, and taking into account that the challenges to the procurement processes are flimsy, the delay should not be overlooked. Then it refers to the decision of Gajima in paragraph 82. They say we do not even get to the Gajima principle of whether the decisions to award the tenders and the service level agreement should nonetheless be set aside in terms of section 172(1)(a) of the Constitution, as no clear unlawfulness in the awarding of the tender and the contracts was shown on the facts. There's accordingly no reason to interfere with the order granted by the High Court, and therefore the appeal was dismissed. So here, my lady, there's not even an allegation of unlawfulness on the part of the 10th and 13th respondents. There's no explanation for the delays, and therefore, my lady, we say it's their conduct that caused the delay, even in relation to this application, my lady, to launch an application, subsequently file an expert report on which you rely, then amend your notice of motion and put in a supplementary finding affidavit to change the cause of action and to change the relief sought, in itself causes delays that have never ever been explained. At paragraph 115, my lady, at page 96-33, in dealing with the Matara report, the 13th respondent makes it clear that it does not intend to appoint its own experts to rebut the contentions made in the applicant's expert report. However, the 13th respondent comments as follows in respect to the Matara report. Now, my lady, it's important to bear in mind that the respondents here dealt with these projects. They have personal knowledge, and they can and are in a position to challenge the factual allegations in the Matara report simply because they are experts in their own field and they explain who they are in their affidavits. So the 13th respondent, and a lot would be the same in relation to the other respondents, my lady, cannot be regarded as lay people who didn't know what these projects involved and what work was done by their respective companies. And that's a fact that I ask your ladyship to take into account when having regard to the situation that we now find ourselves in. Now, my lady, as promised earlier, but before I move over, my lady, in relation to the non-joinder, I wish to refer your ladyship to the decision that you've already been referred to, and I'm not going to repeat it, my lady. I'll just give you the references: Judicial Service Commission versus Cape Bar Council, 2013, Volume 1, SA 170, at paragraph 12, my lady, where the issue of having a direct and substantial interest was established and upheld by the court.
Sorry, what paragraph did you say, Mr.
Paragraph 12, my lady. It's paragraph 12 in the decision of Justice Brunt. It's at page 176, my lady. And we say that it's clearly distinguishable because there the argument was that whilst they might have had an interest in the outcome, joining them wouldn't have had an impact on the rationale of the decision that the court had to make. Here it's different, my lady. Your ladyship has heard we were dealing with an emergency situation. There were, so to speak, diversions taking place. And it would be important to hear from the person who appointed these respondents as contractors why and in what circumstances they did so and what justification they have, particularly, my lady, where there's no allegation of malfeasance or turpitude on the part of the respondents. Another authority or case that I wish to refer your ladyship to before I move on to the applicant's reply, my lady, is the decision that was also referred to by my learned friends for the applicant of Whiteman Trading as JW Construction versus Headfall Proprietary Limited, another. It's a decision of the Supreme Court of Appeal, Justice Hare, 2008, Volume 3, SA 371, at paragraph 13, where he explains that there must be a real, genuine, and bona fide dispute of fact, and it's the one that Mr. Orense referred to as that a bald or bare denial would be insufficient. But we're not dealing with that here, my lady. It's not a case that the respondents, being the 10th and 13th respondent that I represent, have merely just said, well, I dispute that, and not put up a version. They've explained in detail why they dispute it and the basis for doing so. If I may then turn, my lady, to the reply by the applicant. It's filed in a very strange place, my lady. It's we had it in a different file, but it's the reference on case lines, my lady, is 100-14. And my lady, I'm only going to highlight very few aspects in this reply where they deal with my clients being the 10th and 13th respondents. So your ladyship can go immediately to page 100-96. And at paragraph 374, the applicant repeats that the 10th respondent is the only respondent which was able to obtain its own full expert report. And at 375, they state the following: the content thereof is not dealt with by Ms. Matara in the form of a rebuttal report, but is rather incorporated herein. Nevertheless, Ms. Matara has considered the content of the report fully and confirms as correct what I set out herein by way of her attached confirmatory report already referred to above. So we have a situation, my lady, this is what I alluded to earlier, that you have the applicant who subsequently filed an expert report under extreme time constraints, a respondent being the 10th respondent who files a different expert report dealing with the same facts, coming to different conclusions and different amounts, and then you have the applicant not filing any report dealing with that expert report, merely obtaining a confirmatory report. But your ladyship will see that very little issue is taken of the facts pertaining to the expert report by the 10th respondent. Now, on the same page, my lady, in paragraph 376, the applicant states as follows, and it goes to the crux of what I argued earlier, my lady. I quote, "It is admitted that the fraud and corruption pertaining to the overcharging itself have not been expressly set out. However, the position is not the same in relation to the appointment process itself." So, my lady, how can they hope to disgorge profits on the basis of overcharging, fraud, or corruption, when on their own version they have not expressly set out the basis for doing so. That's an admission, my lady, at paragraph 376. And it goes on, my lady. It says, however, the position is not the same in relation to the appointment process itself. But, my lady, your ladyship has heard, and I can go through the same process from Mr. Tsatsani, that there's nothing untoward, corrupt, or improper attributable to his client or the 10th or the 13th respondent in relation to the appointment process. And if there was, my lady, then the people that were responsible and conducted the appointment process ought to have been heard in this matter. And if they kept quiet, my lady, or refused to cooperate, that in itself, my lady, would speak volumes. But their exclusion from the process is unjustifiable. I turn the page, my lady, to paragraph 380, still in the applicant's reply, and it's where the following appears. While I admit that reference was made to an expert's report in my founding affidavit, I was explicit therein that the expert had not yet had time to prepare a final report, and accordingly that it did not exist at the time I deposed to my founding affidavit. In fact, the same remained the position as at 11 February 2022, when the case management meeting referred to herein took place. So there, my lady, despite what was argued yesterday, you have under oath the admission that as at 11 February 2022, when the case management meeting took place, the applicant was not in possession of a final expert report by Ms. Matara, the one that they rely upon. They then continue, my lady, because I want to put everything before your ladyship, in paragraph 381, still on page 100-97, and say the following. It is completely misleading and disingenuous for the 10th respondent to assert that it had to file a Rule 3512 notice to obtain delivery of the expert report. The applicant had nothing to hide and was open and transparent with the respondents as to the difficulties it had encountered with its previous experts and the necessity to then belatedly appoint Ms. Matara. I refute with disdain the inference that the applicant had to be compelled to produce its expert report. Well, lady, all I say in response to that, because this was the reply, is I urge your ladyship to please have regard to the case management meeting minutes that have now been filed, my lady, in the section 78 of case lines. Nothing could be more incorrect with respect. It's clear.
Sorry, Mr. Hurdes, is that the minute for the 11th February that you're talking about?
As your ladyship pleases, yes, my lady, because that predates the date that the report was provided, and it makes clear that we had to file a 3512 in order to obtain that report and any other documents that they relied upon. And they themselves, on their own version in paragraph 381, my lady, had problems and difficulties with their previous experts, my lady, not with Ms. Matara, to then receive documents and even a report. And that's why they say there, my lady, that they had encountered difficulties with their previous experts and then by necessity and belatedly appointed Ms. Matara, which, my lady, confirms what was stated by the 10th and 13th respondents, that there were severe time constraints placed upon Ms. Matara to complete her report with the litigation ongoing at the time. And one would expect, my lady, on account of that, at the very least, they'd say, our experts are of this view. What do your experts say? Let's have a meeting and let's see what can or cannot be agreed upon in this regard. Then, my lady, as I had previously alluded to, the reference that I was referring to earlier, my lady, where they merely note the experience and qualifications of the expert, is at paragraph 417, 417, my lady, at page 100-103, where they merely say these allegations are noted. Yeah, my lady, I turn the page to page 100-104, paragraph 421. And this is what's stated here. From 420, they say, in the 10th respondent's affidavit, it says that Mr. Stewart found its contract price to be reasonable. I have not found any reference to this finding or statement in Mr. Stewart's report. Notwithstanding this, I set out here under the applicants, Ms. Matora's and Ms. Selelo's responses. And I'm going to quote some of them to your ladyship, even though your ladyship has the papers, my lady. They set out in the sub paragraph to 421, where they expressed the difficulties that they had. And I'm only going to quote a few, my lady. 421.1. None of the 10th respondents' payment certificates were provided to the SIU, so this cannot be commented upon. Now, my lady, that's fundamental and basic to any report. If payment is in dispute and you now want to adjust the profits made and you don't even have regard to the payment certificate because you don't have them, and no explanation is provided for their failure to have them. 421.3. Mr. Stewart obtained in that site of far more documentation than Ms. Matora, which enabled him to complete his report. My lady, that's the clearest indication that they ought to have sat down with us and negotiated or allowed the experts to exchange information. It continues in 421.3. I note that much of the documentation he was favoured with was that requested by Ms. Matora in her report, but was not made available to her. Mr. Stewart further had meetings with various of the 10th respondents' representatives involved in the project, which Ms. Matora did not. 421.4, my lady. The applicant has not had sight of the initial email said to have been sent on 20 March 2020, inquiring about the 10th respondent's availability to be appointed to the project. 421.6. The program of works dated 20 April 2020 has not been seen by Ms. Matora. It continues, my lady. The point that I'm making, my lady, is that there is every indication that the applicant did not have sufficient evidence, information, documentation for Ms. Matora to come to the conclusions that she did in her report without putting in qualifying clauses. They're saying, if I see the document, I might change my mind, or I haven't had sight of the document, so I cannot comment further. Well, lady, I then turn to the aspects in the reply that deal with the 13th respondent.
Just give me a moment. Give me a moment.
Yes, your ladyship pleases.
Yes, carry on.
So this is, I'm now, my lady, at page 100-150, under the heading of answering affidavit of the 13th respondent, where they respond to it. And at page 100-151, paragraph 565, the applicant, who's argued to your ladyship yesterday that they can rely on hearsay, states as follows. This being the case, it is submitted that any particularity provided by the 13th respondent pertaining to events surrounding its involvement with the project is hearsay, and the contents of its affidavit did not need to be evaluated with this caveat in mind. Then, my lady, the next paragraph, 566, still on page 100-151, in relation to the 13th respondent, where he said that he had not committed any offences of fraud or corruption in relation to this matter. The following is stated by the applicant. These allegations are admitted. However, the preliminary findings of fraud and corruption made pertain solely to the appointment process itself. It is clear from a reading of that application that the SIU's case was that the procurement embarked upon was unconstitutional and thus invalid. Now, my lady, those are legal conclusions that Mr. Tatswani told you. One cannot read into this anything illegal, untoward, or corrupt on the part of the 13th respondent. In fact, they themselves do not have anything solid to lay at his door, and no proof of any turpitude, as the case is referred to it, on his part. I then turn, my lady, to page 100-156, paragraph 601, where the applicant says, I note that the 13th respondent has elected not to appoint its own independent expert in this matter. All its criticism of Ms. Matare's report must, in the circumstances, be seen for what it is, partial and unsubstantiated. 602 on the next page. This is particularly egregious in the case of the 13th respondent, whose only affidavit is deposed to by the opponent and does not appear to have any first-hand knowledge of the work done by the 13th respondent at the AGA hospital. So, my lady, what we are saying is that in this case, the applicant approached the court originally without an expert report on its own version, had attempted to obtain expert reports, didn't receive them. Then at that stage had already seized and frozen funds in the accounts of at least the 13th and 6th respondent, even in excess of that which they stood to claim in any claim for the profits made. Over and above that, my lady, it then went ahead with litigation, issued an application, still without an expert report, subsequently filed an expert report, didn't join important witnesses who had a direct and substantial interest in the outcome and could influence the decision. And then, my lady, asked this court at this stage to come to its assistance and set aside the contracts and disgorge the profits. And we say with respect, my lady, that that cannot be correct. And the authority, and what we believe ought to have happened if this was a trial, my lady, is the decision that's referred to in the heads of SIU versus Zilwa Trading Proprietary Limited and Mpumalanga Department of Social Development. It's a decision of Modiba J. that involved a trial relating to the COVID-19 pandemic. And there it was found, my lady, that paragraph 12, the SIU had led no evidence to establish the allegation that when it appointed Zilwa...
Sorry, Mr. Hodes, are you reading from your heads now?
No, from the judgment, my lady.
Oh, from the judgment of Zilwa.
Of Modiba J. Zilwa, yes, my lady.
Zilwa.
Zilwa, yes. Z-E-E-L-W-A.
Yes, I know that. I just didn't know where you were reading from.
I apologize, my lady. Paragraph 12. I'm only going to do a few quotes from here. The SIU led no evidence to establish the allegation that when it appointed Zilwa, the DSD did not follow the prescribed procurement procedure. We have the same situation here, my lady. Paragraph 13. None of its other witnesses presented evidence that establishes a prima facie case that Zilwa's appointment was unlawful and irregular. The same applies here, my lady. I turn to paragraph 20, my lady. I therefore find that the SIU has failed to establish a prima facie case that when the impugned transactions were concluded, Zilwa failed to follow the applicable procurement procedures. And we say that applies here too, my lady. In paragraph 23, the third last line, it appears that Ms. Satali compared prices without reference to item specifications. Then at 24, they take issue with whether a particular table could be used as a benchmark. And then they say further, the approach followed by the SIU to benchmark prices for PPEs supplied by Zilwa without reference to the specifications renders the approach arbitrary. And then, my lady, at paragraph 29, my final quote from this judgment, my lady, the SIU's mandate includes, amongst others, the investigation of dishonest conduct on the part of those implicated in procurement irregularities. It is important that the conduct of its officials is transparent and above reproach. When it conducts itself in the manner it has in this matter, the prejudice the SIU may cause those implicated in wrongdoing could be immense and irreparable. Zilwa attested to the prejudice it has suffered as a result of this action when it opposed the postponement application. It has been hampered in doing further business with the state. And then in that instance, as I said, my lady, there was absolution from the instance in a trial. The lady should just bear with me. My lady, in relation to just and equitable relief, there's the decision that's also been referred to in our heads, my lady, of SIU. This is National Minister in the Department of Public Works, Plebeian Property Proprietary Limited. And I want to just quote from that, my lady, a few quotes towards the end of that judgment, also by Justice Modiba. Paragraph 118, my lady, to tell that there is therefore no basis for the conclusion the SIU seeks to draw that plebeian properties induced the award of the bid by fraud. At paragraph 125, in the last two lines, Public Works is aware of the allegations of maladministration against it and has elected not to dispute them. So there they were joined, my lady, and they didn't dispute it. Then under the heading, my lady, just and equitable relief, at paragraph 130, and I'll only quote two paragraphs here, my lady.
When you said, sorry, which paragraph 130 of your heads?
No, my lady, in the judgment.
Oh, okay.
I'm in the plebeian properties judgment, my lady, Modiba J. This tribunal is not limited to the just and equitable remedy proposed by the SIU. When formulating a just and equitable remedy in terms of section 172(1)(a) of the Constitution, the tribunal may make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect. Then in paragraph 132, it is therefore appropriate that the parties are afforded an opportunity to file further affidavits addressing the issues raised in 132 above for the determination of the appropriate just and equitable relief. So there, the court recognized that there was insufficient evidence before the court and it couldn't decide, and it then appointed or put forward that a third party, independent party, should be put forward to assist in the determination. My lady, if one has regard to the Siangena Technologies case that's been referred to extensively by people that have argued ahead of me, my lady, it's quite clear that in that case, my lady, there were allegations of fraud and corruption laid at the door of Mr. Montana. If one just looks at paragraph 15 in the middle, it says, as the GCEO, Mr. Montana simply ignored procedures, bypassed committees and manipulated documents to favor an outcome to the advantage of Siangena. This is repeated, my lady. I'm going to give you in paragraph 21. And the point that I'm making, my lady, is there it was clear that there was turpitude attributable to them, and therefore there was a basis to set aside the contracts and claim back the profits. It's not the case here, my lady. And the final case that I wish to refer your ladyship to is also a decision in the SIU, or another decision by Justice Modiba during the COVID-19 pandemic. It's the SIU versus the MEC for Department of Treasury, Free State Province, MEC for Free State Department of Health, Abikundu, Africa Khlala Investments, and Nzili Group. And here, my lady, there was a position where, and this is what I had alluded to previously, my lady, where it was now a case of giving back the goods in order to get back the money. And at paragraph 93 of that judgment, my lady, it reads as follows. The SIU prays for an order in terms of which all the respondent entities pay back the money they've been paid by the Free State Treasury Department in terms of the RFQ. Such an order would be just and equitable if the departments were able to return to each tenderer the surgical gowns that delivered to the Free State Department of Health particularly in light of the respondent entity's own culpability by not submitting SANS 583795 certificates, since the department is unable to return to each bidder the ground supplied by it, such an order would not be just and equitable. So there, they then appointed an independent expert to assess the fair value, my lady. And the point that I'm making is that there had to be a restoration of the previous position in order to see that it was just and equitable. That's not possible here with respect, my lady, where work has been done on the hospital, services have been provided, equipment has been supplied, to now turn and say, well, just let's turn back the clock, so to speak, and restore the position ante, so that we know exactly where we stand. My lady, I'm almost done. I just wish to align myself, as I have said several times, with the address to your ladyship by my learned friend, Mr. Tsatsane. And I wanted to take one or two points just to one step further and amplify them, not repeat them, my lady. And we say it's on the principle of subsidiarity. You're bound by Paja, as he said, and one can't forum shop and decide, well, in this instance, we're going to go to the tribunal. We're not going to follow Paja. We say that the applicant was bound to do so. My lady, as he pointed out to your ladyship, there was a site visit on the 16th of March 2020. The people that attended that site visit weren't in a position to determine what was a fair amount. Therefore, to say that a budget had been agreed upon of 50 million rand that then was expanded upon exponentially is not accurate with respect, my lady, because there was no basis to do so. And the other issue that we agree with him, my lady, with respect, is that this isn't a self-review. A self-review would have involved, and it's true to fact, unfortunately, it just shows how bad the situation is. If the SIU, and we know that this has actually factually happened, had ordered PPEs themselves, and they looked into their own processes and wanted to set aside their own contracts. In other words, the SIU taking action on account of something that they themselves had done, then it would be a self-review. That's not the case here, with respect, my lady, and can never be the case, where the persons that we've identified who had a material, substantial and direct interest in the matter and the outcome of the matter and could have assisted this court were not cited. We therefore, my lady, ask for costs, including the costs of two counsel, and we ask your ladyship in that regard to bear in mind that at least the 10th respondent filed an expert report. There is no way, with respect, my lady, that this matter was capable of being resolved on the papers as they stood, and it made it clear that they ought to have agreed to have referred the second leg to try not put us through this application to seek relief under the guise of just and equitable relief, when in fact and in truth they knew there were these disputes of fact and that they were irresolvable on the papers, and we had requested them to do so on numerous occasions, and they simply refused, which resulted in these volumes and volumes of documents being read by all the parties involved, including your ladyship. And we know with respect, my lady, that it cannot with respect be resolved on the papers. I have no further submissions unless your ladyship wishes to hear me in any particular aspect. I want to highlight, my lady, that I did not read my heads out because your ladyship said that, but I don't wish to change, alter, or remove anything from the heads of argument. We stand by all the submissions made there.
Thank you, Mr. Hollis.
Thank you, my lady. Then all that remains for me to do is to thank your ladyship and to ask my lady that I'll be excused tomorrow and the following, that my junior and the respective attorneys will be in attendance, my lady, and I'll be on standby. But I don't want your ladyship to be misled into thinking I'm here when I'm not here. They will definitely be in attendance, my lady.
Thank you. Yes, and unless you are specifically required, now I'm sure you can be excused.
As your ladyship pleases. Thank you, my lady.
Thank you, Mr. Hodes. Right. I understand that Mr. Ellis is going to follow now. Is that correct?
Yes, thank you, my lady.
All right. And you can obviously finish in an hour, because I see that.
I will do my best, and perhaps.
Oh, you're freezing up. Sorry, Mr. Ellis, I didn't hear that. The screen keeps freezing up. You said you'll do your best, and?
I said I'll do my best, and if I go 5 minutes over, I'll buy my learned friend, Mr. Tatsawana, a drink.
Okay, so we're going to have a lot of well-fed counsel in this matter, I see.
Lady, I've virtually nothing to say apart from the heads that we were filed, and as well as the very eloquent addresses by my learned friend, Mr. Tatsawana and Mr. Hodes.
Well, I see you were very strategic to let them go before you, Mr. Ellis, so that it leaves you with little to say.
I'm for the 11th respondent, lady. I just wait my turn, as the court pleases, my lady. My lady, I align myself on behalf of the 11th respondent with everything that Mr. Tatsawana and Mr. Hodes argued, and on that basis, I'm not going to repeat anything that they said. If something that they said appears in our heads of argument, it must just be taken that those remarks are in alignment with what they said. I tried also not to repeat everything that's said in our heads of argument, and if I don't if I don't repeat anything, I don't intend to abandon any argument that is raised in our heads. Milady, allow me to start off first by pointing out an irony of this case to Milady. And that is an irony that has gone by of the first and second respondents vis-a-vis the other respondents. We have been told that apart from the declaratory relief or the review relief relating to the agreements, the lease agreements between the state and the first and second respondents, no further relief is sought against them. They can go off happily with the hospital that we have built for them. Now,
and which you're not going to be able to claim back any benefit for.
Absolutely, my lady. We have no cause of action against them. We don't have any contract with them. And the state of the law in regard to enrichment in this country, we can also not claim back anything from them. Having said that, my lady, it is absolutely impossible for your ladyship, in the face of an assurance by my learned friend, Mr. Arendse, that negotiations are being held with the first and second respondents as to a settlement of the issues between them. Your ladyship cannot even begin to determine what damage the state has suffered as a result of anything that the other respondents did. But I'm doing no more than pointing out this irony that would make it absolutely impossible for your ladyship to adjudicate this case. The second reason why we say that it is impossible for your ladyship to adjudicate this matter other than to dismiss the application is the well-known Plascon-Evans rule. Plascon-Evans, the Rumeyer case, and all those cases, incidentally, Plascon-Evans was not the first case in which this principle was laid down. It was just summarized in that case.
Yes.
But be that as it may, we all know the Plascon-Evans rule. And that is that you take the facts stated by the applicant, which are not controverted by the respondent. And in any place where there is a difference or a dispute of fact your ladyship has no alternative than to accept as the gospel truth what the respondent said on that issue. There is no way that the court can say, well, I decide the matter on probabilities. It is not allowed in terms of the Plascon-Evans rule. On this basis, my lady, I would submit that as far as the applicant and the 11th respondent is concerned, there is an irresoluble dispute of fact on both the merits as well as the remedy. If I can go to the merits and the legality argument, we align ourselves with all the arguments about Paja, about the court not having jurisdiction to hear the matter and the like. We're not going to argue those. I'm concentrating on the facts as they are as far as the 11th respondent is concerned. My lady, the first point that I wish to make is that the 11th respondent can be distinguished on the facts from most other respondents, in that the 11th respondent appeared on the approved list of contractors, and that is something that Mr. Arendse has conceded.
The panel, you mean the panel, the contract?
Contractors panel. The contractors panel, my lady, was appointed in a fair and open and transparent manner in terms of the regulations that were applicable. The second, which I submit is equally common core, and that is 180 degrees against what my learned friend Mr. Arendse argued. Mr. Arendse argued that no procurement process was followed. Mr. Arendse is wrong. The procurement process that was followed in the case of the 11th respondent aligns perfectly with the regulations and the Treasury instructions applicable. If I may refer, my lady, to the Treasury instructions dealing with COVID procurement.
Just give me a moment.
The lady will find them in the case lines reference 028-406, and that is the National Treasury Instruction number 07 of 2020 to 2021. I'm referring in that case particularly to paragraph 7.6 of those regulations. It reads as follows. It says paragraph 8.1 of the National Treasury SCM, that Supply Chain Management Instruction Note number 3 of 2016 to 17, preventing and combating abuse in the supply chain management system, states that accounting officers / accounting authorities must only deviate from inviting competitive bids in cases of emergency and sole supplier services. Now, this is not a sole supplier service. This was an emergency. And I think nobody in these proceedings can deny that it was an emergency procurement process. It then says paragraph 8.2 of the said instruction states that emergency procurement may occur when there is a serious and unexpected situation that poses an immediate risk to health, life, property, or environment, which calls an agency to action, and there is insufficient time to invite competitive bids. This clearly falls within that category. It then carries on in paragraph 7.7. The emergency procurement provisions provide for accounting officers, accounting authorities to procure the required goods or services by other means such as price quotations or negotiations. and I underline these words, negotiations, in accordance with Treasury Regulation 16A 6.4. The reasons must be recorded and approved by the accounting officer or accounting authority or his delegate. The next paragraph says it must be reported within 10 days to the relevant Treasury and or Auditor General. Now, we contend, my lady, that what happened in this case was under the emergency regime set up by this set of regulation. Negotiations took place in terms of Treasury Regulation 16A 6.4 insofar as it was possible, and that resulted in the contract with our client. In our heads of argument, my lady, we deal specifically with the factual situation. We set out in paragraph from paragraph 12 right through to paragraph 45, the process that was followed in order to negotiate a proper price. And we submit, my lady, that if one has regard to all these factual statements that were made by the 11th respondent, upon which your ladyship has unfortunately no other choice than to accept what was stated in the 11th respondent's answering affidavit, we submit, and the submission is contained in paragraph 45, it is submitted that the contract was concluded, not as contended by the SIU in March 2020, but only on 11 June 2020. The transactions and correspondence between March and 11 June were part of the negotiation process pursuant to which Ikusasa was appointed as contractor. Now, my lady, that brings me to another point where we submit with the greatest of respect towards our learned friend, Mr. Arendse, that he is completely wrong. And that is that this was a contract where the contract sum grew from 50 to 500 million rand. There never was a contract for 50 million. Not with the first, second, third, or any of the other respondents. Not individually and not collectively. Where the 50 million came from, nobody knows. The only person who would know is the person in charge of the budget of the Gauteng Department of Health, because it is that person who decided to set aside 50 million rands for this project. If there had been an internal misrepresentation of what this would cost, clearly that misrepresentation cannot be visited on any of the respondents, and least of all on the 11th respondent. Because the 11th respondent, from the word go, said, listen, we cannot become involved in this project even though we like to do that. We cannot start because we don't know what to do. We cannot start because we do not know what the pay is going to be. And that is the history that occurred through the negotiation process. The fact that a so-called letter of appointment was issued in April, where no price was mentioned and where no scope of work was mentioned, cannot, by any stretch of the imagination, be regarded as constituting a contract, because the contractor didn't know what he had to do or what he was letting him in for. The same goes for the second letter of appointment, which is nothing but letters of intent. Your Ladyship will ask me, but how come did the 11th respondent find itself on site prior to the contract being signed? That is an everyday occurrence in the building industry, where a contractor, in the hope of securing the contract, starts firing up its resources and establishing on site. But until such time as there is a properly signed contract, there is no contract. And whatever the contractor does, he does at risk. So that, in my submission, my lady, does not make this a corrupt contract. The reference to corruption is used by the applicants in their heads of argument on page 50 in paragraph 93.
So just give me a minute. That is the SIU's heads.
SIU's heads, page 50, paragraph 93.
93, thank you. Yes.
There they make the following startling statement. A further ground of review relied upon by the SIU for setting aside the contracts of the 3rd to 14th respondent is their overcharging or unreasonable / non-market related pricing adopted by them. Overcharging constitutes misconduct and an abuse of the supply chain, which is, we suggest, a form of corruption. My lady, that statement is absolutely incorrect, let alone the fact that the SIU has not proved overcharging, and my learned friend, Mr. Arendse, especially said in this tribunal that he cannot prove overcharging in these proceedings. Now, before I get to the expert statement, I just want to make the following observation. And that is that this is not the type of case where one can separate the question of legality from the question of the remedy. There are cases, and my learned friend, Mr. Houdis, referred my lady to them, where there was a corrupt relationship between the government official and the contractor, and never mind what came out of that, that contract was tainted by corruption. This is a far cry from it. There is no way and no allegation made that can be even remotely approach an allegation of fraud or corruption against my client. What the SIU does is that they rely upon the figures to say, well, look at the figures, and there you will find the problem. There you will find the overcharging. And what do, my lady? They rely on the report of Ms. Matara, a quantity surveyor, and on the report of a person who analyzed the programs of the contract. Now, just as a bit of background, how does one prove overcharging in terms of a building contract? First of all, you have to determine the scope of the work that was done, because if there was a charge for 50 light bulbs and you go on site and you count only 40, then there were an overcharge for 10 light bulbs. Here, Ms. Mutara did not visit the site. She had no idea what the scope of the works were, and it is trite law that the scope of works do not appear from a bill of quantities. The bill of quantities is merely a schedule of rates in accordance with which the contractor is being paid. The contractor does not build in terms of a bill of quantities. The contractor builds in accordance with the scope of works that are set out in the plans and drawings that he submitted to, and all of these Ms. Mutara did not have by her own admission. The second...
Just a minute, just a minute. So you say he does not charge in terms of the bills of quantities, but by the drawings and what's the other thing?
My lady, I say that the contractor does not build in terms of a bill of quantities. The contractor builds in terms of the scope of works, and the scope of works are not found in a bill of quantities. The bill of quantities is merely a schedule of rates in terms of which he gets paid.
Okay.
In order to determine the scope of work, one has to analyze the drawings and compare that to what you have on site. You look at the drawings and see how many light bulbs need to be installed, and you go on site and count. Now, neither of these two exercises were done by Ms. Mutara. Now, secondly, if one analyzes a bill of quantities, one must distinguish, or one must determine whether the bill of quantities that you are examining is compared to a comparable bill of quantities. You cannot, for example, take the bill of quantities for a 50 million rand house that is being built by a millionaire in Sandton, and take that bill of quantities and compare that to the bill of quantities of a hospital. By the same token, you can also not take a bill of quantities for the upgrade of a hospital that was built 50 years ago and has been standing empty for 30 months, such as the AGA hospital, and compare that to the Sinto Care Hospital. And my learned friend, Mr. van der Vyver, gave my lady the reference to that. And the reference, I'll ask my junior just to get the reference. The Sinto Care Hospital being a hospital that was built brand new, a state-of-the-art, totally green hospital built in Menlyn Mine in Pretoria before the lockdown. In fact, it was completed, it was started in 2018 by Ms. Mutara's own calculation and completed before the lockdown. So she was comparing apples and pineapples. In my submission, my lady, that should be the end of any reference to what Ms. Mutara did. But the 11th respondent went infinitely further than that. The 11th respondent went so far as to get an expert to respond to Ms. Matara's calculation. The ladyship will find that expert report in case lines 091, page 1597 and onwards. In that case, or in that document, Mr. Conrad Jan Erasmus of the well-known firm Matlock Quantity Surveyors sets out his criticism of Ms. Matara's calculation. He starts off on page 1599 by saying, on a different basis than I've just argued, that she was not comparing apples with apples. Says the relationship between the original scope of works and original budget was proposed. It is discussed in detail by the author of the report. It is merely noted that they feel that the cost is excessive based on a per bed cost. The cost, however, included the refurbishment of housing, converting areas into ICU, and changing of acceptable standard to ensure to most amount of ICU beds possible can be accommodated. It's not very good, elegantly worded, but what he says is that what Ms. Matara did is she simply said, well, it costs so much to build a hospital per bed. She did not take into account that our bill of quantities and our scope of work included the refurbishment of the housing, converting areas that were not ICU into ICU, and to change the building to acceptable standards. He then says in the second paragraph, we believe that their focus for the report included in section 1 is flawed due to their express opinion that they could only review rates submitted by the contractors and no detailed information was available. Now, there's yet another point of very great diversion between us and the SIU. The SIU, in their, Mr. Du Toit, in his answering affidavit, goes so far as to say that they do not know what was paid to the 11th respondent, and they could not establish that because of the fact that the 11th respondent did not provide our payment certificates. But he's wrong. We did. He simply disregarded it. He closed his eyes to it. And that is that statement is found in the replying affidavit, case lines 100-124. The 11th respondent's bill of quantities was attached at 091-354.
So just give me one moment. 091
554.
Sorry, you're breaking up there, Mr. Ellis.
Apologize, lady.
Yeah. So you said
091 354.
354.
Yes, that is where the bill of quantities is found. We also attached the payment certificates from which it is exactly clear what we were paid and how we were paid. So, milady, my submission is that what happened when and I'm not going to read the whole of Mr. Erasmus's criticism. I think
I have been through it, yes.
Your Ladyship has read that, and I submit that the criticism that he expresses, albeit on a provisional basis, because Ms. Motaro says that her report is only a provisional report. In the 5 or 6 pages of his statement or his report, he, with respect, annihilates Ms. Motaro's report, and no reliance can be placed on that. Milady, similarly, the 11th respondent is criticized for going over the time. Now, the date for practical completion was stated in, Your Ladyship just bears with me a minute.
Just remind me again, your client was responsible for LOA 3, not so?
That's correct, yes. That's correct, my lady. In the contract, the completion date was stated as the 4th of December 2020. And that, Your Ladyship, will find on page 091//759. Apologies, my lady. That was the date that we achieved, not the contractual date.
So, yes, 4 December 2020 is when you actually completed it.
That is when we actually completed the
I can't recall what was the initial completion date.
My lady, I will, if Your Ladyship just bears with me 1 minute, I'll get to that.
No, I'm serious, but I recall that there was another date and it was actually handed over or finished in December 2020.
Correct. That is correct. Now, the 11th respondent is criticized very heavily for the time overrun and said, well, you know, you went way over the time and you should have, you were not entitled to any contract time extensions because the time extensions were not approved by the department. Now, the contract does not provide for approval of a time overrun by the department. The contract provides that that is done in a very, very stringent application form by the contractor addressed to the project manager. Now, in this case, the project manager is one of the parties before this court. Had the SIU properly interrogated the issue, they would have received proof of all those time extensions. Mr. Erasmus mentions them in his report. They are attached to the papers filed, and in the light of all of this, the SIU in their replying affidavit pays no attention to them and contends in this forum that there was an illegal and unlawful time overrun. Penalties were not charged where they should have been charged. And my submission is that the SIU simply got their facts wrong. And the facts on which they rely, insofar as it differs from the facts on which the 11th respondent relies, the Plascon-Evans rule goes. I come back to the point which I made earlier, my lady.
One moment, Ms. Evans, one moment. Thank you.
The lady, if I may just ask your ladyship to make a note of the reference to the comparative hospitals that Ms. Mutara used.
Just give me 1 sec. Let me just go. Yes, here we go. Yes.
They were mentioned on page 087
Yes. 087
180.
Okay.
For example, there she refers to a 300-bed Jubilee Hospital based in Hammanskraal, COVID wards priced in June 2020. She then refers to the Sinto Care Hospital and then other similar recent HVAC. Now, HVAC project is simply a reference to the air conditioning system in BOQs in Zutari's possession. So my submission is that her comparison fails right from the beginning. Lady, the point that I made earlier was that unless Milady can find that there was a overcharge of rates or an overcharge of items in respect of anything that the 11th respondent did, there can be no finding on the basis that the contract was illegal, because the process that was followed was not illegal and the payments were made strictly in terms of the contract. And what is more, my lady, we here sit with the 11th respondent situation where they in fact completed the work. There are no snags to attend to. The work was in perfect order and handed over to the department. This is typical, the situation where the victim would be applicable, and I'll get to the reference now, where the court said that it would send a chilling message to contractors out there who bona fide tenders for work, undertakes work on behalf of the state, completes the work, and then finds themselves in the situation where they must submit them to a process which my learned friend Mr. Arendse calls a disgorgement of profit. I now need to deal with the remedy proposed by Mr. Arendse. The remedy is, well, I cannot tell your ladyship now how much must be disgorged. I simply do not know. But set aside the contract so long, and let's go on to a next step. The next step is a statement and debate of account. My lady, my submission is that there is no basis for such relief. The statement and debate of account, and that is dealt with very fully in our heads of argument, is a remedy where there is a relationship of uberrima fides, such as a partnership between the parties. We also refer to authority in the heads of argument to the effect that contracting parties, such as an employer and a contractor in a building contract, does not constitute the type of relationship where statement and debate of accounts is an appropriate remedy. The only basis on which my learned friend for the SIU wants to have a statement and debate of accounts is because they want the respondents to afford them evidence that they can use against them. Now, my lady, if ever there was an injustice, there would be an injustice, this would be one. The law does not provide for such a remedy. My learned friend asks your ladyship to create such a remedy when none exists. What would happen, and I put this question no higher than that. What would happen if your ladyship finds at the end of a process of statement and debate of accounts that the 11th respondent owes nothing to the department? What would happen if your ladyship finds that, as we contend, the department still owes us money which had been retained in the process of issuing payment certificates? How would your ladyship then be able to revise the finding of illegality? Lady, I submit, for all the reasons set out in our heads of argument, that there is no basis for the relief sought by the SIU against the 11th respondent. We make the point, or we are making the point, that my learned friend, Mr. Arendse, used a number of sweeping statements to create nothing but atmosphere. For example, the statement, and it is with respect a reckless statement to make, that the contract grew from 50 to 500 million. It didn't. The contract didn't grow 1 cent. He further made the point that it is common cause that no negotiations took place between the parties. Lady, that is not true, and we set out the negotiations that took place. My learned friend did not respond to that. My learned friend also argued that there was no...
Just a minute. Yes.
My learned friend also argued that there was no approval for an expansion of the project. Now, I take it that the expansion is now the expansion from 50 to 500 million rand. I submit that the project did not expand. If anybody made a mistake here, it was the department who, as a result of the hysterics that reigned this country in April 2020, underestimated the project. And that is not something that can be laid before the door of any of the respondents. Lastly, my learned friend argued the shall I call it, the Plascon Evans point by saying that, and he puts two arguments forward. The first one is, well, that is how the SIU does things. But that doesn't make it right. The second argument is, he says, well, that is the process that Justice Modiba determined at the case management meeting. That can surely not be a reason for following that process. Surely Justice Modiba did not hear argument during those proceedings on the applicability of Plascon Evans or otherwise. She simply made a procedural arrangement based on what the SIU already did. My lady, under these circumstances, I would ask your ladyship to dismiss the application with costs, including the costs of 2 counsel. This is not the type of case that your ladyship would, at this late stage, refer to trial, and in any event, one does not refer half a case to trial, but the whole of the case. It is also not the case where there are limited issues upon which the evidence can be adduced, so that one can simply listen to a couple of witnesses on a restricted list of issues. This is not the case that should be referred for oral evidence. Lady, there is no other way to deal with this case than to dismiss it. Dismissal of this case is not the end of the world for the SIU. They can still issue a summons. Dismissal of the application is a dismissal tantamount to absolution from the instance. That basis, my lady, I would ask your ladyship to make an order dismissing the application and ordering the SIU to pay the 11th respondent's costs. My learned friend suggested that costs should only be paid in the alternative by those opposed the application.
Sorry, Mr. Ellis, you broke up there again for a bit. It must. You said in the alternative. What was the alternative?
The argument, Mr. Arendse argued that if relief is granted, then he wants costs against only the respondents who opposed the application. My submission is that there is no reason to mulct the opposing respondents in costs where other respondents may have been at fault, and they should also be carrying their burden of the costs. But I submit the ladyship will probably never get there, because this application should be dismissed with costs. Thank you, my lady.
Thank you. Thank you, Mr. Ellis. Right. Well, I see you kept to your promise, and we still have a few more minutes left to 4 o'clock.
Thank you, my lady.
Good. All right. Well, I don't think that we are going to be able to continue. So that leaves us with Mr. Keller. It's only you for tomorrow.
Thank you, madam.
My lady, I'm also still in the queue.
Oh, sorry, Mr. Klopper, of course, number 6. So it's just you and Mr. Keller tomorrow.
That's right.
Yeah, okay, good. Well, then we'll also get hopefully, Mr. Arendse ready to reply as well.
Thank you, my lady.
Good.
I'm not sure, my lady, whether we should perhaps utilize the few minutes that we are left with, in particular on my side, to deal with the whole 6533.
Sorry, I can't hear you very well, Mr. Killer.
In particular, my lady, to deal with the notice in terms of 6533. I understand that.
I don't know if you're going to do that in 4 minutes. I think it's going to take you a lot more than 4 minutes.
Thank you.
Yeah, somebody's got their mics on. Yes, now I think we can just, do that all tomorrow. We can start with Mr. Klopper and then go on to you tomorrow and deal properly with those issues.
That will suit me. Thank you so much.
Okay. Thank you then. Thank you, gentlemen and ladies. I know not too many ladies spoke today, but you're all there, I know. Thank you very much for today. We will then take the adjournment until tomorrow and we'll resume tomorrow. Thank you.
It's a pleasure, Court, my lady.
Thank you.